you want me to go ahead and give it to the clerk right now to have actual files? Can't we look reading the door they were out tonight?
Okay. You got copies and everything?
We have copies for.
Okay.
No, that's your. You can keep that, and I'll go file another copy if you want me to. Isn't that big of me? To let you keep that?
Mario, I can take it.
Yeah. Okay, thank you. Yeah, we're following the motion.
Just the top one, right?
First address. Get up there and we'll get you a copy. My grandson can't wait to meet a little. Yeah. Can't wait to continue working on soccer. Thank you.
I thought the IT people would be here, but I can probably do about 15 minutes of questioning and then I'm going to have to shoot videos.
He told us this was Wednesday.
He's coming, Judge.
He is coming.
Right now?
Yeah, I called him.
Yeah. 12, set out October 23rd at 1:30. I guess civil eviction, I guess, procedure or something.
Thursday, 1:30. Let's check. I want to make sure I got the schedule.
Is our motion related to your cross?
It's.
You need a sticker?
No, one to IDO.
They're all up there, sir.
And then to make our arguments. So that after, but it's mainly the issue of answer. And giving them help is very important. And we attach as exhibit No, that's for the judge. Thank you.
Oh. Hold it, and then I have that.
You thought, is it in the system already?
So I'm entering it right now because I just got it back there.
All the jurors are here?
Yes, sir.
You guys ready to go?
Judge, I do have an issue I'd like to discuss or bring up to the court before we start.
Can y'all turn that light or That's
Thought you were
perfect.
being- Thought you were being interrogated, Judge?
I felt it. I felt it.
That's for your lawyer.
I'm seeing spots.
It's in her judge.
Okay,
Judge,
Is this on the record, Your Honor?
yes, please.
okay. Hold on,
I'm bringing it-
call it, since Mary is.
Okay.
not here. This is 2023 CR 11510A, B, and C. Present in the courtroom are attorney for each defendant, and all three defendants are also present in the courtroom as well as the state. The jury is not yet here. Defense?
Yes, Your Honor, but I'm bringing this issue on behalf of all three defendants. The last time that we were in this court for an excessive use of force case, the only people that were here that last time were you and me and Jay Norton and Mr. Harris. And at that time, they were making a similar argument that our officers had no right to go into the house after that man. And at that time, I'd asked the court to stop them from making that argument because it's wrong. It's wrong on the law. The law is clear, it's been well established. It's even been well established in this case with these facts and circumstances. And then if the court remembers, at the end of the state's case in chief, their expert got up and testified that yes, they did have every right to go in there without a warrant. And I bring it up because in this case, the same thing is happening again. So they're making an argument here that is the exact opposite of the argument they're making in every other courtroom in this courthouse. And so, and the court knows, and we all know here that it's not the law, that the law does not require officers to get a warrant in these circumstances. The fact that they keep insisting through their witnesses that that is the case, and with that juror note that we got yesterday, premature, but it's clear that it's actually having an effect on the jurors' consideration. So my argument is it's not fair that the jurors are the only people in this courtroom that do not know the proper law, which is that they do not have to get a warrant in that circumstance. It is not required. I guess what I would ask is if they're going to continue to make the argument, I'd like to have a hearing in front of the court and have the court make a determination of what the law is, so that we're not telling the jury an improper law. They don't have the right just to make any argument they want to make. They have to make an argument that comports with the law. And as the state of Texas, their duty is not to see convictions, but to see justice is done, and that means applying the law the same way in every courtroom in this courthouse, and not having it flipped on its head and applying it in a completely different way than they would argue it everywhere else. And so it's weighing on me because of what has happened before, and it's weighing on me because I know that the jury is considering that. They're thinking about whether or not that there needs to get a warrant. Their witness testified that he did, and he was completely wrong. The federal court has said that there was an exigent circumstance in their ruling and in their opinion in this case and under these facts. And so again, and subsequent to that, we think that that's also a relevant matter now, because they are having witnesses testify to something that is completely inappropriate and not the law. And the jury has a right not to be confused under 403. It's confusing the jury to tell them that there has to be a warrant in this case. And it prejudices the due process rights of our clients, because they have a right to have the jury know what the right law is and not to judge them on getting a warrant when that was not a requirement in this case. And since you are the judge of the law, and the jury should not be, we'd ask that be settled if that's pleasing to the court, and if it is settled that they did not have to get a warrant, then we stop talking about the fact that they did.
Additionally, Your Honor, I join in Jason Goss's argument. I want to expand a little bit on the fact that we filed a motion that the court take judicial notice of the federal court opinion, and I believe that the state has opened the door for now to be an appropriate time for that to be admitted into evidence and published to the jury in its entirety at this point in time. And Rule of Evidence 202 permits judicial notice to be taken at any time and to be introduced at any time. So we ask that the court do take judicial notice of the federal court opinion and that it be published to the jury before we begin testimony. In addition, the state's expert, Chuck Joyner, who they gave us notice, and we argued in the motion in limine that the state, I believe it was September 8th of this year, listed Chuck Joyner as their expert, and number 8 never told us that they were not gonna call him as an expert, and in his own report, he stated that the arrest was lawful, and that the officers have the right to be present. So again, I would join, my co-counsel, or counsel for the co-defendant, Jason Goss, and ask that, they be barred from mentioning it, and also, we ask that the court take judicial notice pursuant to our motion in 202, that it be admitted, that it be published to the jury.
Your Honor, and if I could just add a couple of other things to that. That report from their retained designated expert was given to us about a year and a half ago. It's been on file since then. They weren't going to say anything about it until Mr. Lunan and Mr. Harris were pushed 3 times in the pretrial hearing, and then they finally said, we're not going to use him. And then they referred to his report as a disclosure. The court well knows disclosures from their office come with big black lettering that says disclosure. That was a report. Therefore, they're trying to speak out of both sides of their mouth, and the jury's entitled to know that their own retained expert says this was a legal arrest. And they weren't going to tell us about it until the eve of trial. And under Rule 801, it's admissible as an admission of a party opponent by an agent, and it's admissible as an adoptive admission by an agent of the district attorney's office. And I would further say under the due process clause of the 14th Amendment and the 5th Amendment, and under the 6th Amendment right to compulsory process, and we've supplied the Supreme Court cases going to the compulsory process right we have to frame our defense, that report should be admissible into evidence. The jury should not be, it should not be hidden from them that for a year and a half they're speaking out of one side of their mouth that this is what our retained expert is going to say, that this case is governed by the reasonableness requirement of Graham v. Connor, which the federal court followed, and that this arrest was legal. The other thing I want to point out for the record is when Mr. Goss was saying that the federal court found that the officers acted reasonably and there was exigent circumstances, Mr. Lunan and Mr. Harris were smiling and nodding their head that that wasn't the case. The court has a copy of the opinion. The court can read the opinion, and what Mr. Goss said is factually and legally right on the money.
Your Honor, may we respond?
Yes.
It's the state's position that all these arguments are without merit, and we welcome you to read the opinion on the federal court opinion. And I remind the court, the federal court opinion had no application to Nathan Villalobos, okay? And by virtue of their joint agreement, they wanted the case to be tried together. It has no application to Nathan Villalobos whatsoever, and it would be in the balancing issue prejudicial in that matter. And second, it contains hearsay. It's a hearsay. It's an opinion of one person, maybe even 2 persons. It's not admissible in a criminal proceeding. And third, as we've discussed ad nauseum previously, is it has no application to state law. It has an application to substantive Fourth Amendment issues about use of force. It has nothing, relates nothing to do with the added restrictions that the state of Texas has placed on police officers when making an arrest inside someone's home. Completely different dynamic. They didn't address it. You can read the opinion. Won't be addressed in there because they're not applying state law principles. So it absolutely would confuse the jury anyway because its conclusions have no merit as to the issues that this jury is going to be asked to decide. With regard to a witness giving an opinion that was not endorsed or sponsored or placed on trial by the court does not make him an agent of the state for the purpose of a admission by party opponent. It's simply a person who gave an opinion that we disagree with, that we gave them notice of immediately. They had notice of this immediately. They had notice of this entire statement a year or so ago. The fact that they don't like that the law under 1405 of the Texas Court of Criminal Procedure says that police have no authority to arrest someone inside their homes without either consent, a warrant or an exigency. That's what the code says, Your Honor. 1405 says that. We are not making this up. An exigency has been defined in some instances as hot pursuit, which is what we went to argue, and it is a factual issue for this jury to decide whether or not the pursuit of Melissa Perez was both immediate and continuous, which is required in the cause. I've got cases for you to look at, Judge. That is a fact issue for the jury. It's not an issue for the court or for these lawyers to decide. We want to make that factual determination for them and preclude them from deciding whether or not these officers acted unlawfully in going into Melissa Perez's house. So I will happily provide cases. I also have provided these cases, or at least a couple of these to you, during jury selection when we were talking about the rights of the court to instruct the jury when a defendant asks for self-defense, is pursuing a self-defense claim, that the judge can sua sponte, or at the request of the state, include a instruction to the jury that says what the victim's rights were with respect to defending herself, or in the instance here, protecting her property. And I'll give those cases to you again so you can take a look at those and digest them. But we're not doing anything improper here. We're doing everything within the realms of the law. They just don't like it.
Your Honor, as to what I like and don't like, it's none of his business, and he doesn't have any idea first. But second, what I don't like is injustice. What I don't like is when they argue one thing here and they argue a totally opposite thing everywhere else. But I'll tell you, the case, they specifically say a suspect cannot defeat an arrest that had been set in motion in a public place by the expedient of escaping to a private place. I mean, that's what this is. That's what our last case was. And as we've talked about, their expert agrees that they are all there lawfully. And so, as far as what they're doing, they are using this, and they're trying to use this argument to substantially injure our clients' rights. I mean, to substantially injure their ability to defend themselves by throwing mumbo jumbo into the jury box that's not the law. I mean, the law has been established. You cannot run away from an arrest into your house and expect that the officers aren't going to come in after you. That's it. They will and they can't. There's no ollie oxen free. There's no home base in the law. There never has been. And they would never argue that there is anywhere else but right here, right now with these three defendants. And that's, so for us, and one of the things that's kind of sparked this is what we got from the juror, which, is not relevant in the scheme of things, but it does kind of show that they are considering that these officers need a warrant to get in that house. And the law just says they do not. And they never have. And there's as much case law as they can provide. There will never be a case that says if you're able to evade arrest on foot in a public place and get into your house, that you're safe. And that the officers can't go follow you in there.
But I think it's more than that, Judge. I mean, it's one thing whether it's, and we're not saying it's illegal entry, but it's another thing that they're actually arguing that you can use force against an officer for that. And I asked this officer that the remedy to that is to come into a court like this and to do a motion to suppress. And to conflate those issues is confusing. If they need a warrant to go into a house, which obviously they do not, and I think it's clear, but then is it okay for her to use harm against them and use force against them? Because as I posed the question to David earlier, and not that he was a witness, but to this witness yesterday, that they would be prosecuting her for capital murder if she would have killed any one of these officers. So that's, to me, that's even more important, that's getting confused. The fact that they're this underlining theme that they're trying to thread through this trial is it's an illegal entry, and they needed a warrant. Therefore, she can use a hammer to defend her property. That's insane. And David, you know it's insane, right?
I do not know.
So yes, you do, sir. And so that's what the problem is here, Judge. And that's what's being conflated. So on top of what Mr. Goss was arguing and Mr. Cifuentes, I think that's an extra layer of confusion, Judge, that the jury is obviously considering. They would harm their rights to due process and to be treated fairly, not just before this tribunal, but before this jury.
And I'd like to, no, wait.
All right,
Go.
hold on. I already got all the arguments. Are y'all done arguing, or?
Judge, I have two things that I need.
Okay, all right, let's get the arguments out.
Okay, so defendant's exhibit number 23 is the use of force, or the procedure 501, response to resistance. And it specifically says that limited by the federal statutes that deal with unnecessary or excessive force. And this witness already testified that there's been no finding of unnecessary or excessive force. So it's within that guideline. And then I asked him questions about 501.07, which I used the metaphor of a steamroller beats rock, paper, scissor, and that you can use any means necessary. And so what it basically says is it disregards policy. Now, it's disingenuous for them to argue 14.05 and exigency because the way they argued it, and I'm going to be careful about grand jury proceedings, but the way they argued exigency and have argued exigency is using the San Antonio Police Department definition of exigency, and that's not the law. They are free to impose a more restrictive, SAPD is free to impose a more restrictive definition of exigency than case law, but the consequence of violating SAPD policy on exigency is discipline, not criminal prosecution. And what the court of, the federal court made clear in Judge Bimperod's report was the facts that existed, which included the invalid man, which there's been testimony about here, supported the exigency. And they've introduced the videos of Eleazar Alejandro, and Judge Bimperod stated in his report, Eleazar can be heard on its body camera saying, oh, and I'm going to say bleep, we have to go in now, when he was pointed to the invalid in the bedroom. And so what Judge Bimperod said is that statement established exigency. So as a matter of law, exigency has been established by the evidence that's been introduced in this case, and the law is clear under the federal rulings that it was exigency, and therefore we're asking two remedies: that they be stopped from saying that it was an unlawful arrest, and number two, that the report and order be introduced into evidence at this time and be published to the jury before we proceed any further.
And, Your Honor, I just wanted two things, two pieces of law that have not been discussed. During voir dire, Mr. Lunan kept talking about, well, if you display a hammer to the jury and you want to create an apprehension that you might use deadly force, that you might be okay in doing that. You're not actually using deadly force, but in displaying the hammer, he was talking about that's a use of force. Well, under 9.41 defense of property, you can only use regular force, okay? But 9.31 says you cannot use force to defeat even an illegal arrest. This arrest was completely legal that they were trying to execute for multiple aggravated assaults on police officers, but so they can't use that argument for 9.41 because of 9.31. So then you have to jump to 9.42, deadly force in defense of property. And really that's the only argument that, because as we've all seen from these videos, she was not simply carrying a hammer around in her apartment like the media has portrayed. She was actively attacking several officers with bad intentions. And 9.42 says you cannot do that unless they want to argue that these officers were trying to commit a laundry list of specific felonies that are enumerated. Unless they want to argue to this court and this jury that all of these officers were trying to commit a burglary or a robbery or an aggravated kidnapping, none of those apply. So they've been arguing throughout this case and misleading this jury, arguing against not only Texas law, but the Constitution of Texas and the Constitution of the United States. And for Mr. Lunan to keep saying that the constitutional law does not apply in this case, when every day in this courthouse, lawyers are consistently citing the 5th, the 6th, all of the amendments as applied to the states via the 14th Amendment. So it's completely disingenuous for them to make that argument.
Your Honor, you can- you can
two
be
things
followed
very
for-
short.
All right, so let me hear from Mr. Norton, and then we'll wrap it up, because
And I believe Mr. Nesbitt has a small nugget that he wants to include as well, but as to the defense of property that she's allowed to use force, 9.02, the penal code starts, it is a defense to prosecution that the conduct in question is justified. It's not, it doesn't even go to her. 902 clearly makes it a defense to prosecution. And as to Mr. Lunen's point that only 2 of the 3 defendants are listed in that court opinion, that's because Mr. Villalobos had previously been dismissed out because there was no constitutional violations found against him already. That's all I had.
He was dismissed out because there was no wrongful death suit involving him. And this whole thing was a wrongful death suit. He wasn't charged with wrongful death. That's why he was omitted from the opinion. It says it in there.
All right.
Judge, bringing up the caboose here, for the state to ply you with case law and then call Bemperad and Beery mere conclusions and not authority on the subject is spurious and two-sided. The court will recall in the state's opening statement, Mr. Harris made strenuous argument about violating Ms. Perez's constitutional rights. And we would argue that's exactly what that federal opinion is saying did not occur, right? Civil rights are constitutional rights, i.e. rights under the 4th Amendment. Those are rights to illegal search or seizure. That is the heart of the argument that the state is making. You can find it conflicts with 931 in the state statute, and we all know the way statutes are to be applied. The legislature knew what they were doing. They don't create conflict among statutes. They can be applied on their face. That should be a legal bar to what they're applying right now. But also, if they're saying it's a constitutional civil rights violation, and that's the very division that's sitting at that table right now, that is the heart of that federal opinion. And the essence of that opinion is there were no civil rights, no 4th Amendment rights, no search or seizure rights violated in this case. Mr. Goss highlighted this, so I'm going to read it straight out of the opinion. And they had a reasonable basis for believing that entry was urgent, given the combination of Perez's violent and erratic behavior with the presence of a bedridden old man in the apartment with her. Just that is exigency. It's part of a federal opinion that was adopted and ratified. Thank you.
All right. Now, State, you wanted one last?
The defense, by claiming that the officers acted in self-defense, requires by its very language that the person that they used force against was acting unlawfully. And if there is evidence that the victim, in this case, Melissa Perez, was acting lawfully in defending her property under state law, under Section 931, Section 941, and the officers were acting unlawfully, as Code of Criminal Procedure Provision 1405 defines what lawfully and unlawfully is with respect to entry into a home without a warrant. And thus far, the evidence is and will continue to remain that they had no consent and that they had no warrant. And so a fact issue remains for this jury to decide whether an exigency existed. In one of the cases, Ratliff, I gave you, was an official oppression case where an officer went into someone's home after they had probable cause that the actor living inside the home had committed some crime. And the court said they can't go into the home just because they have probable cause to arrest him for a crime, because they did not engage in a immediate and continuous pursuit of that individual. Therefore, their entry into that home was unlawful. This situation, according to our facts, is no different. And it's for the jury then to decide if an exigency did not exist, if they don't provide any facts of an exigency, it's a fact question for them, then they can resolve that issue in the defendant's favor. If they do not find an exigency, a consent, or a warrant, then they will resolve that issue in Ms. Perez's favor. they were acting unlawfully in trying to enter her home. And if they are acting unlawfully, she has rights under the state constitution, under the state statutes, to defend her property. And it's in the black letter law, Your Honor, that we went through in jury selection and that I forwarded to you here now.
Your Honor, if I may, to add to Mr. Wynn's opening argument, as the jury has already seen with the state's evidence and videos, the initial officers, if there's even a colorable argument that this was hot pursuit over the hour and a half, now listen, that there was not, they ended that arrest. They had each turned off body cams, gone to the parking lot, gained additional information, and then when they went back, that was a new matter entirely. You cannot just omit that. This jury has already seen that, and at that point, they needed a warrant or consent or exigency. That is the state's position, and Supreme Court decisions that the offense is omitted. Specifically, I'll cite Barnes v. Felix, 145, Supreme Court 1353. They want to narrow all of it down, ignore the facts, which the jury has already seen. I say again, that these were two separate and severable events, and then hone in on exactly the 30 seconds around 2:02 a.m. when they then again, without consent, without a warrant, without exigency, respectfully, defendant's assertion we have to go in now belies all the other objective evidence at the time, and that will come out with additional witnesses and additional body cams. So to now claim, as we've already started the evidence, because they don't like the court's pretrial rulings, it's no way, Your Honor.
Your Honor, we were making these arguments before the trial
And
started.
you got ruled against.
And no, he held it in abeyance.
So-
And it's interesting, they're citing Supreme Court law, which Mr. Lunan was just saying federal opinions are hearsay. So I guess we can't rely on any opinions from the Court of Appeals.
If-
All right, hold on. All right, so is there any new arguments that we have to make here? Because I've already heard the same arguments regurgitated several different
I'd like to
times.
respond to Barnes v. Felix.
Yes, you can respond, and then the court's gonna rule.
Okay. Counsel for the state has referenced Barnes v. Felix. Interestingly enough, Barnes v. Felix rejected a Fifth Circuit opinion that says you focus on the last 2 minutes of the incident, that they still follow Graham v. Connor, which is the totality of the circumstances. So the state doesn't want us to talk about Graham v. Connor, and in fact, they're citing Barnes v. Felix that says Graham v. Connor is still in place. Now, the totality of the circumstances actually supports the reasonableness of the force, because there were several aggravated assaults prior to the use of force in the last 2 minutes. There was, in the 20 minutes beforehand, there was a lot of talk about the aggravated assaults, witnesses of the aggravated assaults, people talking about the hammer and so forth. So we're not focusing on the last 2 minutes, even though the criminal conduct happened in the last minute of the accused attacking these defendants. And interestingly about Barnes v. Felix, that was one of the very cases that Judge Bimperod cited in his report. So if they want us to believe that Barnes v. Felix controls, and you should be persuaded by Barnes v. Felix, then certainly, if Bimperod relied upon it, his order should be relied upon as well.
All right, so the jury charge is gonna have all the law, right? The court instructed the jury initially that they cannot begin deliberations until the court gives them instructions to begin deliberations. That's gonna be at the conclusion of the evidentiary portion of this part of the trial. So, I will provide to each of you a proposed charge, which has already been prepared. That's gonna have the law. I'm gonna deny the defense requests for the court to take judicial notice of the federal court case. We've already hashed that out. We did it during pretrial. I'm sticking to that ruling. I'm gonna grant the defense objection to preclude the state from calling this an unlawful arrest. Everything else should be a fact issue. Does that make sense?
Your Honor, without calling it an unlawful arrest? can we provide the evidence, and will the jury ultimately be instructed on whether or not the officer under 1405 is acting lawfully or unlawfully in making an arrest in her residence?
We can make that later, that determination later on in the trial, depending on evidence that comes in.
Your Honor, can our experts, as experts who are entitled to rely on hearsay or anything else, can they rely on the opinion of the federal court here in the Western District that this was reasonable? Are they entitled to rely, are you gonna say that that was one of the pillars that they're relying on for their opinion?
We can talk about their opinions, we could talk about things that they've relied on without making specific reference to the federal court case. Specifically the ones that y'all are talking about, that federal court case, because it relates specifically to whatever thing. This jury's gonna get the same evidence or other evidence that y'all want to put before them, whatever the case may be. I don't have any concept what that federal court case was, just because I wasn't present at the time of the evidence, but whatever evidence came in, you'll have the opportunity to provide that evidence before this jury.
The opinion, with all due respect, says that he looked at the body cameras that have been introduced in this case. He gave a narration of
Are you
what
talking, you talking about the court?
Yes, Bimberod.
Okay, so we're not gonna get into the court's rulings.
Okay.
Or the court's opinion, but evidence, whatever evidence you wanna attempt to be, and now remember, both sides have an opportunity to object. So if there's something that y'all don't like, I mean, I'm not gonna rule specifically on legal issues, other than y'all have the ability to object when that time comes, as it relates to the testimony. Y'all object, and we deal with it then, and then we go from there. That make sense?
Whatever your ruling is, Judge.
All right.
Yes, Your Honor, we're clear.
Okay. Let's bring it on. Oh, you're gonna work on the, okay.
Barbara has that document, it's gonna be in the back.
Okay.
You need anything.
Okay.
I'm gonna grab that water real quick.
Oh, there it is. Let's just wrap around that.
Yeah.
Yo, Dave, everyone get out of there. Get out of there.
Were you able to get the Bluetooth on that one? Yes. Okay. So y'all are separate now. You have your own Bluetooth for that one, and he's gonna have his own over here.
Thank you very
You don't
much.
have to stop. All right. Thank you. I think they're good.
Fixed?
Everybody's good. Did you go through it or you keep that?
All right, let me get,
Okay, perfect.
I'm gonna give each of y'all a very preliminary charge now. But I only have 2 copies at the moment.
One for us?
One for y'all, let me get one for the defense. Just one. You can always make copies.
Pressure's on.
You can always. Appreciate it, Judge. Yeah, I only got so much paper here. Y'all ready?
We are.
All right.
We're resuming and crossed by Ben, right? Yes.
All right.
Had you already started cross, Mr. Suplee? Had you already, okay, that's right.
He showed us how to switch it back to our side.
All rise for the jury. Maybe seated? Everybody good with the correct note cards, everybody? Thank you.
All right, members of the jury, welcome back. Hope you've had a pleasant day so far. We anticipate going through to the end of the day. Today, I believe we're working on our dockets now to make sure that we can do all day the next 2 days. I think the trial's going a little slower than what we anticipated. Where we last left off, defense, we were at your cross. You may continue.
We need the witness.
You've been sworn.
Yes, sir.
Can I approach that camera?
Yes.
Is that what you wanted to? Yes. Officer Rojas, you're familiar with, well, let me show this to you first before we start looking at it. Can I approach witness?
Yes.
This is defendant's exhibit number 1. You recognize that, correct?
Yes, sir.
And what is that?
It's an incident detail report.
I'm sorry?
Incident detail report.
For this call that you're testifying about today, correct?
Yes, sir.
All right.
Can you turn his microphone on, Ben?
This is mine.
Can you test it?
That's it.
All right. All right, I'm gonna flip to, page 3 of that IDR. Orient it better. Can you tell the jury what's the significance of this time that we have above the pointer? Whoops. The significance of this time that we have above the pointer.
The 622, the 2332.
Yes. What's the significance of that time?
It's a response time.
Okay. Well, do you know how to read an IDR?
Yes, sir.
Okay. If I were to represent to you that that's the time that the first call came in, would you agree with that?
Yes, sir.
Okay. So the call came in at 11:32 the previous day, correct?
Yes, sir.
All right. And if we go down, we can see when you responded, correct? Actually, in fairness to you, I believe we need to actually go to the second page. You were 61, you were 61, 20C, correct?
Yes, sir.
And you arrived at 12:43:17, correct?
Yes, sir.
So the call had been holding for over an hour and 14 minutes or so?
Yes, I believe so.
All right. And flip to 5610. Whoops. It's 5610, and it says Jesus Rojas response. Explain to the jurors what that is.
Is that's the time that I entered her information. I don't think it's my working.
And would you agree with me that you did a copy and paste her information from another screen.
Yes, sir.
And would you agree with me that when you run someone, you're supposed to run it correctly according to how you're trained? And there's a phrase that people use in patrol called the long way, correct?
Excuse me?
The long way.
I don't know what that phrase is.
So, well, did you run it the way you were taught?
I ran her information to our system, yes.
The way you were taught,
Like I said, I ran the information to the system.
all right? And it comes up to another page, doesn't it? It's on another screen that you run the information, correct?
It's on our MBT.
Right, but it's not the IDR screen, it's another screen, correct?
Yeah, it's a different screen on the MBT.
Okay. It's another program on the MDT. Would you agree?
Like I said, I ran it on the MBT.
You don't know what program you use?
Judge, I'm sorry, I don't think they can hear.
Yeah, I can't
The mic's not working.
really hear them.
It's not even.
Counselor, do you have the other mic? No, he's got it over here.
That's dead.
Is it on?
That's dead.
It's dead?
Yeah.
Where's the other mic at, Counselor?
One's here, the one that was here is now up here.
I don't think we need this one, Judge. We're allowed here.
That's
Now proceed.
Yes.
The MDT is the laptop computer, correct?
yes, sir.
All right, and the laptop computer has different screens or programs or databases, correct?
Yes, sir.
All right, so when you run somebody, you don't run them on the screen that has the IDR, correct?
No, sir. We run them on one of the systems on the actual on the CAD, on our CAD
Yeah,
network.
and what do you call that screen?
It's just information, I guess. Where
And that has access to someone's criminal history, correct?
yes, sir.
All right, so when you run someone's name on that screen, you are able to pop up their criminal history. Would you agree with me?
Their history comes out first. Then you got to get their SID and paste it a different and run their SID by itself so you could get the actual criminal history.
All right, and that's called the long way of running someone, correct?
Yes, sir.
And that's the correct way to do it, correct?
It's one of the ways to do it.
And you do it the correct way, correct?
Excuse me?
You do it the long way, don't you?
Like I said, I got her information first, and I copied and pasted on the computer.
Okay. When you run when you run their name, you run it what's called the long way, correct?
Like I said, when I ran the name, I ran I put her first and last name and date of birth, and that's what I got.
And then you ran her SID.
I
as
did not
well,
run her
did you?
SID.
I'm sorry?
I didn't run her SID.
Okay, so by not running her SID, you failed to follow proper procedure, correct?
It doesn't tell you what point in time you have to run her SID.
Are you telling me that your FTOs never told you to run?
It never tells you when to do it.
I'm sorry?
It never tells you when to do it. You can do it at any point you want.
Okay, that's not my question. Did your FTO, your field training officer, ever tell you that when you run someone, you're supposed to run it the long way, where you run their name and you get their SID and run their SID?
Yes.
Okay, so you ignored what your FTO told you to do, then, is what you're telling this jury.
Like I said, I didn't get to that point yet.
I'm sorry?
I didn't get to that point.
Okay, you were in the car for 8 minutes, were you not?
Yes, sir.
And this return came up before the 8 minutes expired, correct?
Yes, sir.
So you actually ran her information before 5600, correct? Or 1256.
Yeah, probably a little bit before.
All right. And so if you ran her information at 1256, you had you went into the car at around 1250, 1251, according to your body camera, right?
Yes, sir.
So you had 6 to 7 minutes to run her on the computer, did you not?
Yes, I did.
So you had plenty of time to run her completely, did you not?
Yes, sir.
All right. And so if you had run her the way you were supposed to, you would have come up with her criminal history. Would you agree with that?
Yeah, if I was with around her, yes.
So, but you're telling this jury that you didn't run her the correct way and you didn't see her criminal history. Or are you telling her that you ran the criminal history the correct way and didn't see her criminal history? Which is it?
Like I said, I ran her name and date of birth, and her information pops up. In order to get the criminal history, you gotta put the SID in there.
Now,
So I was looking at other
right,
calls.
I haven't asked you anything further, thank you. Now, you would agree with me that Officer Salinas showed up at 101:37 according to the key card? You want me to show you? I can show you.
It doesn't say on here. It says the key.
Speak up.
So Officer Salinas is 6340C, correct?
Well, I can't see. Yes, sir.
All right, and according to that, he showed up at 107:37, correct?
Yes, sir.
All right, now, you told us that when he showed up, he took over the call. Is that correct?
Yes, sir.
You're not gonna change your story?
No, sir.
All right. So, at 107:37, he was in charge of the call, correct?
Yes, sir.
And you would agree with me that your body camera policy is set forth in Procedure 410 of the General Manual. You agree with me?
Yes, sir.
All right. Can I approach?
Yes.
Can I approach?
Yes.
I'm handing you what's been marked as a Defendant's Exhibit 24. Do you recognize that?
Yes, sir.
And what is that?
It's procedure 410 of the general manual.
All
Body
right.
worn cameras.
And you're required to abide by that, correct?
Yes, sir.
Go to page 5 of the procedure, and it's under 410.07. Actually, is that a true and correct copy of the procedure that was in effect at the time?
Yeah, I believe so.
All right.
The missing pages. Or back. Okay.
There's no missing pages, it's just printed on front and back, correct?
Yeah.
All right. We would tender Defense Exhibit 24 to the state for inspection and objections of any, and we would offer same at this time.
By state. No objection.
Article admitted.
Now, we were on page 5 of 12 of Exhibit 24, and I'm directing your attention to 410.07, which has the heading, "When a body camera video can be stopped." Do you agree with me that 410.07 states when a body camera can be stopped?
Yes, sir.
All right. Now, I want you to read out loud, well, I'll tell you what, I'll read it.
A says, unless otherwise permitted by this procedure, once the body-worn camera is recording, it shall remain recording until the incident has concluded. Do you agree with that? That's true, correct?
Yes, sir.
And then subsection B has 3 parts, and I'm going to read it. For the purposes of this section, conclusion of the incident has occurred when, 1, all arrests have been made and arrestees have been transported and released from custody. That's B1, correct?
Yes, sir.
And B2 says, all witnesses and victims have been interviewed, and, you agree that 2 says that?
Yes, sir.
And it says, number 3, the continued recording will not serve to obtain additional evidence. It says that, correct?
Yes, sir.
All right, you would agree with me that all arrests had not been made when you stopped your body camera.
Yes, sir.
And you agree that all witnesses and victims had been interviewed when you stopped your body-worn camera, correct?
I said it was the end of the call already.
Okay, that's not the question
It was
I
the end of
asked.
the call.
That's not the question I
Okay, so
asked
what's
you.
your question then?
I asked you, when you stopped your body-worn camera, all witnesses and victims had not been interviewed, correct?
Like I said, when I stopped it, the maintenance man wasn't there anymore. Wasn't there yet.
All right, but you didn't wait for him, did you?
Yes, we did. They said they couldn't contact one, and we left it at that, and we left.
All right, but you agree with me that Jonathan Salinas started his body camera a few minutes after you stopped your body camera because he was interviewing Kenji Uno, the maintenance man, correct?
Yes, sir.
So if you had waited 2 more minutes, you would have been able to talk to one of the witnesses, Kenji Uno. Well, you would agree with that, right?
Like I said, it was the end of the call already.
That's
We
not
were
the
done with
question.
the
That's
call.
not the question
Well,
I
that's
asked.
my
you.
answer.
If you had waited 2 more minutes, you would have been able to talk
When-
to.
when
to
we ended the call-
Wait a minute. Let me finish my question, and I want you to answer it. Had you waited 2 more minutes for Kenji Uno, the witness, the manager, the owner, for purposes of criminal mischief, you would have been able to talk to a witness. Yes or no?
When they told us that they couldn't get a hold of them,
It's
we ended
yes
the
or no.
call.
It's yes or no.
If we would have waited, yes, but they told us they couldn't get a hold of one, so we ended the call.
Thank you, thank you. Now, under 410.08, you're supposed to upload your body-worn cameras at the end of the shift, correct?
Yes, sir.
Explain what that means to the jury.
That means that after your shift, you dock your cameras. There's a docking station at the substation.
All right, and you're supposed to dock all videos recorded that day, correct?
Yes, sir.
All right. And would you agree with me that procedure 410.12 has a section called video categorization and retention, and if we go to page 8, the minimum period for retention is 180 days.
Yes, sir.
All right.
And since we know Salinas took over the call, it was his decision on when to stop the call or the recording, right?
Once he told us it was wrong, that we couldn't get a hold of anybody that who we talked to, we all ended our call.
Sir, that's not my question.
Okay,
You
well,
agree- Listen to my question.
if you want me to answer, I'll answer
Listen
it.
to my question. You agree that since Salinas took over the call, it was up to him to decide when to end the call, correct?
It's up to him when he decides he ended the call for himself.
All right. So do you agree that he showed up at 1:37, he should have been using his body-worn camera at the time he showed up at 1:01:37.
Can you repeat yourself?
Do you understand that when he showed up, he should have activated his body-worn camera, correct?
Yes, sir.
All right, and if that camera is missing, the retention period of 180 days, there's enough time to retrieve it if everybody uploaded their body cameras as required by the procedure, correct?
Yes, sir.
All right. So, now, I understand that people can make mistakes, and I'm sure you've made mistakes, and in fact, in this case, we know Eleazar started his body-worn camera on a previous call, forgot to turn off his camera, and so 2 calls are on the same video. That has happened before, correct?
Yes, sir.
And if that happened for Jonathan Salinas, given the 180-day retention policy, given the fact that you upload all your cameras, they could have retrieved the previous call and caught his camera on when he first arrived at 1:01:37, correct?
Yes, sir.
All right. So, would you agree that we don't have any evidence, or if you don't, we don't have any evidence as to why Jonathan Salinas ended his call as required by Procedure 410?
I don't know that.
All right. And you agree with me that if you end your call, you're required to state the reason why you're ending the call on the body-worn camera, correct?
We're required to at least say that we ended it.
Okay. And you didn't say on your body-worn camera that you're ending the call and why, did you?
I'm not sure, sir.
All right. And if you don't say why on your body-worn camera, you're supposed to write a report, correct?
Yes, sir.
And you didn't write a report saying why you ended the call, correct?
No, sir.
And you agree with me that after you ended the call the first time, within 2 minutes you started the camera up again, correct?
Yes, sir.
All right. And you stated in your witness statement that you had a chance to review all of your body-worn camera. Is that true?
Yes, sir.
All right. And you gave a statement to one of the detectives at around 7:34 or so, correct?
I don't know exact time, but I believe it was later that evening, earlier that morning.
And when you got back to the station, you didn't upload the videos until around 5 o'clock in the morning, correct?
Excuse me?
You didn't upload your videos until 5 o'clock in the morning.
I don't know exactly what time I uploaded them.
All right.
As soon as we got to the homicide office, we docked our cameras.
All right. Now, let's talk about Procedure 611. That is the procedure that deals with the mental health consumer. You're familiar with that, correct?
Yes, sir.
And you would agree that in 611, it says officers should remain aware of the location of their cover officer along with others involved in the situation. You're required to do that, correct?
Yes, sir.
All right. And it also says the officer should keep these persons, the mental health person, under close observation, correct?
Yes, sir.
And that should be maintained throughout the incident, correct?
Yes, sir.
And it says a frisk of the individual and a search of the immediate surrounding areas are conducted in accordance with GM Procedure 502, correct?
Yes, sir.
And I want to make absolutely clear, 611.08 requires you to arrest and book the person if there is probable cause for defense, correct?
Yes, sir.
And after you arrest the person, if it's a felony, you still book them, take them to the jail, but you tell the magistrate why they might be a mental health individual, correct?
Yes, sir.
So in this case, if you knew that a felony had been committed, you were required to arrest her and take her to jail and then tell the magistrate that she might qualify for an emergency detention, correct?
I don't know the felony yet.
I'm sorry?
I didn't know it was a felony yet.
Okay. But when it's a felony, that's what you're required to do, correct?
Yes, sir.
All right. And even if you didn't know if it was a felony, 611.08 A, B, 4B says with the supervisor's approval, you conduct a warrantless emergency detention in lieu of arrest if the person with mental illness has committed a misdemeanor criminal offense other than DWI and family violence. So, before you could ED a person for a misdemeanor, you had to get the approval of your sergeant, correct?
Yes, sir.
And at no time did you contact any sergeant asking for approval to ED Melissa Perez, correct?
We never got to that point.
All right. And the reason we never got to that point is you didn't arrest her, correct?
Yes, sir.
All right. Now, switch. All right. I'm gonna show you part of your body with the camera, and it starts at 45:20, and we're gonna play it. It's already been admitted into evidence.
Map of what their disaster was gonna be from that side of America.
So what happened, man? What happened?
But what?
With the box in there?
What do you want me to tell you?
You told us?
Yeah.
Who you are?
What do you want me to tell you? The anger.
So what happened?
See, once I cut them wires off, there's a lot of audio that went. And then, you don't believe me, I can show you some stuff.
There's a lot of what?
I can show you some evidence. Evidence of what I'm investigating. What am I investigating? What I'm investigating is the harassment of people.
Okay.
The audios, the way they make people sound,
Okay.
the way they make them seem.
Now, I could play this for another minute, but you would agree with me that during these 2 minutes, you had the opportunity to arrest, handcuff Melissa Perez, correct?
Yes, sir.
And had you arrested her, what we see in the next 29 seconds would not have happened. I'm going to show you. Said you could, what we saw just now would not have happened, correct?
If she's in handcuffs, yes, sir.
Right. I'm going to show you the next video. Actually, I'm going to speed it up. This is your cover officer. This incident that we saw previously, but from your cover officer's body camera.
Hey, lady, get over here. Get over here. Hey, lift. Come get your dog. All right. Get him. All right, Melissa, come here. Friends, you got the virus.
All right, and had you arrested Melissa Perez, what we saw there, and that stretch of video from Officer Ramos would not have happened, correct?
Yes, sir.
Now, I'm showing you from your body camera, the time is 1:38:22. What's that, glass that has the yellowish green substance in it?
I don't know.
Isn't that the urine from
I don't know what that is.
Santa Rosa?
I don't know what that is.
All right. Is it consistent with urine?
It could be Gatorade.
All right. So let's watch what happens.
Can you open the door for us? You come ready, one? Alright. If you don't open the door, we're gonna kick the door down. Keep right here. You think you open the door for us?
Everybody here now. Get out. Before I call charges on both of you.
Let's open the door, or you kick it down.
You kick it down, and you're gonna go charges against me.
Alright.
You don't have no warrant. You ain't got no jurisdiction.
All right. You would agree with me whether you had arrested Melissa Perez or not. The San Antonio Police Department could not have abandoned Santos de la Rosa even if you had arrested Melissa Perez, correct?
Can you explain yourself?
All right. Had you arrested Melissa Perez, the San Antonio Police Department could not have left Santos de la Rosa by himself as an invalid, correct?
If they went over there looking for him, then I don't know what your question is.
So had you arrested Melissa Perez, gone to her residence and seen Santos de la Rosa and determined that he was an invalid that couldn't care for himself, you could not have abandoned him. You would agree?
Yes, sir.
All right. All right. This is your body camera, and it starts at 1:40:29.
You could open the.
And I'm gonna back up a little bit. At 1:40:32, Melissa Perez runs from right to left across the screen of view, correct?
Yes, sir.
And she's running fast, correct?
Yes, sir.
And you know later that she comes back with a hammer, right?
Yes, sir.
All right. Let's see what happens.
You could open the.
All right, so at 1:40:36, 1:40:37, you tell Salinas, can you open the screen door, right?
Yes, sir.
All right. And at 1:40:43, in response to your request, Salinas is jumping over the railing, correct?
Yes, sir.
And I stopped it at 1:40:47. I want to ask you to focus in the next second or two on the opening in the window to the right of the TV. And I stopped it at 1:40:49. Did you notice what Melissa Perez was doing at that time?
She was running towards the window.
What was she running with?
But I couldn't see at that.
All right. You saw what she was running with?
No.
All right. But you agree that at this time you yelled, "Watch out, watch out, watch out."
Yes, sir.
All right. And you saw in real time with your own eyes she was running with a hammer, correct?
Yes, sir.
All right.
Your Honor, for the record, I'm just kind of clarifying the picture here. We're looking at Ramos's visual and we're listening to Rojas's audio from when he was at the window in the last screen. Am I correct?
Well, it says Ramos here. I apologize.
This is not his body worn camera, the images.
Well, this is stitched together. All three are stitched together, and the first, this one is, this is your body camera, right?
I don't know.
All right. Well, that is Ramos in the, no, I'm sorry, this is Salinas in the window, correct?
Yes, sir.
And Ramos has yet to show up yet, to the patio, right? Because he's kicking the door, right?
Yes, sir.
All right, so this is your body camera, right?
I guess.
Watch out, watch out, watch out, watch out, watch out.
And when you said, watch out, watch out, watch out, what did we just see?
Miss Perez run at the window with the hammer.
All right? And what did Officer Salinas do in response to that?
Move back. Get out of the way.
And if you hadn't moved back, you would have been hit with the hammer, don't you think?
Could have. Yes, sir.
All right.
You're gonna get shot.
All right, you see this screen on the patio?
Yes, sir.
Do you think would you agree with me that the width of this screen is about 2.5 feet?
I don't know.
You would agree that it's close to that, right?
Yeah, probably.
And so we can tell that if this is 2.5 feet, that anyone standing at the corner closest to the patio rail would be approximately 4 to 5 feet away from the window, correct?
Possibly.
All right.
Come open the door. Hey.
5200 on Pearsall, 5200
All right. So what did we just see on your body worn camera?
Miss Perez throw the candle at Officer Nunes.
All right. And he said, I have one at gunpoint. She has a hammer, right?
Yes, sir.
And the E-tone went out, right?
Yes, sir.
And then she threw the candle, right?
Yes, sir.
Now this is Officer Ramos' body camera in the same scene.
Here, phone.
Now, you knew at this point in time, 1:40:49, that Officer Ramos was trying to kick the door to gain entry, correct?
I was on the other side.
But you knew he was kicking the door.
I don't know what he was doing over there.
All right.
I could see from the camera.
But you never tried to stop him from entering the residence, did you?
Like I said, I was on the other side.
All right. say shoot me?
Yes, sir.
Alright. And we stopped it at 140.56.
Come open the door. Hey.
And what did we just see on Officer Ramos' camera?
Can you play it back?
Open the door. Hey.
What did we just see?
Miss Perez threw a candle.
Alright. And that conduct was aggravated assault on a peace officer?
With the candle?
Yes.
I don't know what they'll justify that. I mean,
So
what the offense?
it's assault on a peace officer, isn't it?
Oh, yes, sir.
And when she swung the hammer 2 times at him, that's aggravated assault on a peace officer, correct?
Yes, sir.
And just for the record, under 14.01, when you see a felony offense committed within your view, you have the authority to make an arrest, correct?
Yes, sir.
And you would agree with me that both Ramos and Salinas drew down on Ms. Perez, correct?
Yes, sir.
All right. And this is going to be Officer Salinas, camera at the same time frame.
You can open the table. Yeah.
All right. And tell us what happened there.
Officer Salinas tried to take the screen off, and Miss Perez ran at him.
Ran at him with what?
The hammer.
She did what?
Swung it at him.
All right. And the hammer came out the window, didn't it?
I'm not sure.
All right.
You're gonna get shot.
And what did we just see her do to 140.54?
She was holding the hammer like if she was gonna try to swing it.
Like she was trying to swing it?
Yes, sir.
There's no doubt in your mind that she was going to try to swing it?
She had it in that position.
Let's see if I can slow this down. Okay, I played that in slow mode. Did you see the hammer come out the window?
Yes, sir.
And did you see her extend it towards Officer Salinas?
Yes, sir.
And you've seen for the last 10 or so seconds that Officer Salinas has his gun drawn and pointed at Melissa Perez. Is he committing a crime there?
No, sir.
Why not?
Because she tried swinging the hammer at him.
And he's threatening deadly force in response to her use of deadly force, correct?
Yes, sir.
And if his conduct's not unlawful, then what you're saying is that Melissa Perez's conduct in swinging the hammer at Jonathan Salinas was unlawful, correct?
Yes, sir. Perez throw the candle out the window.
All right. Now, what we saw with the hammer strikes and these 3 videos and the candle toss, none of those things would have happened had you arrested Melissa Perez when you had a chance, correct?
No, sir.
All right? You agree with me? That had you arrested her, those things wouldn't have happened, right?
All I could do is,
Do you agree?
you want me to answer your question?
Do you either yes or no?
Yes.
All right. Now, this, the time is 2:02:05, and this is Officer Flores' body camera. You were behind him, were you not?
I'm not sure, sir.
You
I was
were
in the
present
area.
when he went over the railing, right?
Excuse me?
You were present when Alfred Flores, your sergeant, went over the railing, correct?
I was in the area, yes.
You saw him, right?
I was in the area.
Did you see him?
I was in the area.
Did you see him, yes or no?
No,
You did not see him.
no. I was in the area, and I was more towards the side of the actual, where the other room was at.
All right, well, let's take a look at him going over the railing, and I'm gonna ask you some questions and see if you agree with me. All right, so his body camera is facing another individual with the beanbag shotgun, correct?
Yes, sir.
And who is that person?
I believe that's one of the Sergeant Rivera.
All
I
right.
believe, I'm not sure. Kind of,
And
but
would you agree that based upon the orientation of the body camera, that Alfred Flores' torso is facing away from the window?
yes, sir.
All right. I'm gonna show you Officer Thompson's body worn camera. All right, well then, we'll use it.
I think we're at 25.
We're tendering for the record, Travis Thompson's body cameras 1 and 2, which are evidence exhibits 25 and 26 for inspection and objection, if any.
Are you representing that these were what we gave you?
Exactly.
Okay, then no objection.
Right there, admitted.
All right. I'm showing you Officer Thompson's body worn camera. Who do we see in the window there?
Miss Perez.
And what is she doing?
I don't know. Standing by the window.
I'm sorry?
All right.
Standing by the window.
And do you know for a fact that she was running towards Alfred Flores?
Yeah, she was running towards the window. Yes, sir.
She was running towards the window, right?
Yes, sir.
And we see Alfred Flores' head above the railing, right?
Yes, sir.
And the time is 2:02:06, correct?
Yes, sir.
And you would agree that at 2:02:06 that Alfred Flores doesn't have the ability to see her approaching, correct?
No, sir. That's poor tactics.
I'm sorry?
That's poor tactics.
Okay, poor tactics or not, he doesn't have the ability to see, right?
Like I said, it's poor tactics. But yes, he doesn't.
He doesn't have the ability to see.
No,
right?
sir.
All Pettis, that was poor tactics, correct?
All I could do is
Yes or
control
no?
what I
Was it
did.
poor
I can't
tactics
control
when you
anything else
failed to
anybody else
arrest?
did.
Yes or no?
No, sir. I was still trying to investigate what I had.
Okay, so you're telling this jury that it was okay for you not to arrest her when you knew she was mental?
We never got to that point.
Oh, well, I thought you testified you knew that she was mental beforehand. And you already admitted that you should have frisked her beforehand, right?
Like I said, we always call for a female when it's another female.
Okay.
The female could frisk her.
I'm glad you mentioned that because not once did you ask for Maria Selena, the dispatcher, to have Maria Selena show up, right?
We never got to that point.
Okay. It's a yes or no. You never asked, you could have asked the dispatcher to send Maria Salinas over, correct?
Like I said, we never got to that point.
Sir, it's not whether you got to that point or not. When you realized she was mental and she needed to be emergency detained, you knew you were required to have her frisked. Yes?
Like I said, we never got
Yes
to that
or no?
point. Once I had her in handcuffs and we're ready to, before we take off, yes, I would have called for her.
All right, so, but you never handcuffed her either, did you?
No, we never got to that point.
Okay, because you failed to arrest her,
Like I said, we never got to that point.
and you admitted that you had plenty of time, 2 minutes to arrest her, and you didn't arrest her. So,
Like I said, we never got to that point.
so you failed to arrest her and you failed to have her frisked, right?
We never got to that point.
So that's poor tactics, right?
Huh?
That's poor tactics, right?
If you look at all those videos, there's a lot of poor tactics on those videos.
All right, so, but are you willing to admit to this jury you used poor tactics, yes or no?
Yeah, sure.
Yeah, sure?
Yeah.
Okay, what are all the poor tactics you used?
Like I said, I didn't get to that point to arrest her yet. I was trying to just keep her calm till cover officer got there and she ran.
So, if the purpose of 611 of the general manual is to provide medical services to people with mental health issues, you failed to do what was necessary for her to get the mental health services she needed, right?
I never got to that point.
Okay. So is it okay to tell the world that you failed to provide services because you never got to that point? Is that what you're telling this jury?
Like I said, it's a process that we do. It doesn't, not a specific process. So I just never got to that point.
Okay.
We're still investigating what's going on.
So let me ask you this real simple. Remember yesterday, before you ever approached Melissa Pettis, when you were at the fire sprinkler box, and you had information from a credible person, Lieutenant Chris Hudson, now Captain Hudson, that she confessed to cutting the wires, that she said she was paranoid, that she said the FBI was listening to her. And I asked you at that point in time, you had enough to emergency detain her. Are you changing your testimony today?
No, like I said, I don't have to put her in handcuffs right away. If she's cooperative, it's up to me to decide when I do that.
All right, so, but the general manual tells you that you should, right?
It tells you as your discretion.
All right, and you knew she committed a misdemeanor or felony at that point in time, correct?
Yes, sir.
And so, when you have probable cause to arrest someone, you arrest them first, and then you decide whether they're gonna be ED'd later, correct? You told us that's what the general manual 611 says.
Yes, sir.
All right, so if you agreed with me that you're supposed to arrest her first and then make the decision to ED later, you would agree with me that you failed to arrest, right?
Like I said, I never got to that point.
All right. So, is that your way of denying responsibility for your failure and your collective duty on this call?
Like I said, I never got to that point.
Is that ever an excuse?
I never got to that point.
All right. playing this video, tell us what we see Melissa Perez doing.
She's swinging a hammer at the window.
All right, and the hammer hits the window at 2:02:07, would you agree?
Yes, sir.
All right, and what are all those sparkly things that we see in the air?
Glass.
All right, and that glass is going outwards, right?
Yes, sir.
And that glass is going in a cone shape in the direction of Alfred Flores, your sergeant, correct?
Yes, sir.
All right, so she's swinging the hammer and the glass is going in the direction toward Officer Flores. You would agree with me that a reasonable person could conclude that she was swinging a hammer in the direction of Alfred Flores, correct?
Yes, sir.
And a reasonable person could believe that her intention was to let go of that hammer and have that hammer go into the head of Alfred Flores, correct?
Yes, sir.
And it would be inexcusable for a San Antonio police officer not to defend a fellow officer under those circumstances. You would agree?
Yes, sir.
Because you have a duty to defend someone from the use, from the unlawful use of deadly force, correct?
Yes, sir.
And her use of force with that hammer at that point in time was unlawful, correct?
Yes, sir.
Now, had you arrested Melissa Perez, when you had an opportunity for 2 minutes to arrest her, all these things that we've seen on video would not have happened on June 23rd, 2023, correct?
There's always every the guest there has a way of, they could do their own thing. I mean, I have no, I can't control what anybody else does. So somebody else that got there, that was in charge, could have done something different.
Okay.
So,
All right, let's break it down. If you had arrested her, she would have been in handcuffs, right?
yes, sir.
And if you had arrested her, you would have escorted her to your patrol car, correct?
Yes, sir.
And had you escorted her to your patrol car, you would have seat belted her in the car, correct?
Yes, sir.
And you would have closed your door, correct?
Yes, sir.
And the back seat of a SAPD SUV patrol car, can you open the door from the inside?
No, sir.
Is there a thing called a cage?
Yes, sir.
And did your car have a cage?
Yes, sir.
So if Melissa Perez had been handcuffed, put in the back of your patrol car, in a caged vehicle with no way to unlock the doors, she would have remained there until you transported her to either the jail or an emergency detention facility, correct?
Yes, sir.
And if she was being transported to the jail or to an emergency detention facility, she would not have the opportunity to have been swinging a hammer at anyone, correct?
Yes, sir.
And had she been booked into jail or detained in a medical facility, she would not have had the ability to swing a hammer at anyone, correct?
Yes, sir.
So, if you had handcuffed her and did what you were supposed to do, you would agree with me, what we've seen on these videos never would have happened, right?
Like I said, never got to that point.
So, if she was in the car, she couldn't have done those things, you agree?
Yes, but she was never in the car. I never got to that
Right.
point.
So, that's what I'm asking, had she been in the car, she wouldn't have been able to do those things, right?
Yes, sir.
And had she been in the car, Eleazar Alejandro, Alfred Flores, and Nathaniel Villalobos would not be here in court today. You agree? If you had put her in the car the way you were supposed to.
I just never got to that point.
Is that your way of excusing?
You can take it whatever way you want. That's just the way, that's my explanation.
All right.
I never got to that point.
All right. Did the chief of police find that excuse acceptable, that you never got to that point?
Like I said, I never got to that point. I was still doing an investigation.
All right, so you have never been charged with neglect of duty or incompetence by the San Antonio Police Department, correct?
No, sir.
And you would agree that your failure to arrest Melissa Perez and put her in a patrol car was neglect of duty or incompetence?
I never got to that point.
So that's what you're gonna stick to? You never got to that point?
Exactly, I never got to that point. I was still doing an investigation.
But the fact is, where you are at this point in time, you have no regrets about your failure to act?
Like I said, I was doing my job the way I always do it. And like I said, never got to that point.
You're doing your job the way you always do it?
Yes, sir.
All right, so isn't the truth that you were upset with the dispatcher and you didn't want to work that night? You were complaining about being crossed over and you were calling the dispatcher dumb, that she was canceling you. You talked about that for over 3 minutes. You stated that the only reason you're on dog watch is you got good Saturdays.
Yes, sir.
And you were unhappy that you were being overworked? that
I
the
never
calls
said
were
I was.
stacking?
I never said I was unhappy.
All right. Well, let's play.
It's okay. You had the papers on my mind. We're good.
All right. Let's play your body camera, and I'm gonna give you a transcript of the time in question. I'm gonna ask you to read it, as it's being played. Approach.
Yes.
I'm handing you, it's been marked as Exhibit 27. I want you to read along to yourself as we play this video. I mean, pay attention.
You want to identify what that is?
It's a transcript of his body-worn camera starting at approximately 1:08:03.
Your Honor, may I hold our witness?
Yes.
Officer Rojas, if during the playing of this and listening to that, you find any inaccuracies between what you read and what you
Yes, sir.
Do you disagree that that transcript is accurate?
Excuse me?
Can you?
Yes, sir.
Discuss if
Yes,
you
I'll listen.
find anything that you disagree with?
Yes, sir.
That's all. You can follow along.
1, 2, and 3 sec is where I arrived at the steps, like right out the gate, and then after that happened, like I was like we're following up, like the robbery came out, and then fucking it was busy. Like it's been nonstop, like like 20 calls plus.
The thing is, she fucking, I was over here at 160, right? So she sent me over cover 250. I get it, 250, we had a rider, right? So, what are the phases they give? I mean, if you had a rider, we're just bidding, man, it's 2 people, man, 2-man unit, right? I mean, at least, so she crosses me over the full cover in. I'm over there, dude, I'm like, down the street, bro, she canceled me, cause one of 2 side, okay, Perez. So I'm way over there by Bishop del Lago, so I start driving back, and then she sends me over here.
I was stuck at UH on major, because their 16-month pay got pretty messed up through that. And so I was there until TAD showed up, and I was coming from Central, and there was an accident in Central, so I took a detour. I was stuck in country. So that's why I messaged you on like, so I'm coming from Central.
Yeah, it's like dumb, you know? 250, yeah, they're under, baby, we're busy, man. You can say we're a 2-man unit, at least till we catch up, you know?
I'm 210 tonight.
What's up?
So I'm 210 tonight. So I'm at the bar watch.
Yeah. But they sent me out there to go cover him, or them. And I was like, I'm driving over there, and then somebody, I guess 221 clears, no, 220 clears, somebody cleared. And they're a lot further than me, and she canceled me to cover them. And literally I'm in back with them. So, So he said, oh, Solano has it on here, and then, so I got it over here, and then he went to the two sites, the Checo lab, I was here, and then he left on, last Saturday or Sunday on the one side.
So help out Tech has Saturday Sundays.
He does also. Oh, what's the name has Saturday Sunday, Cantu?
No. Oh, can't do that Saturday Sunday?
Yeah.
On Wednesday?
Yeah, so he left, and then I went to one side and got his, and
Who has
then,
Saturday Sundays here?
Doug,
On Monday?
yeah. Yeah, Doug has Saturday Sundays over
He
here.
and the three side.
Yes, huh?
He and the three side.
Yeah, so I came over here to get him, and then, cause Solano had him here, Solano took Pacheco's on the two side. So I was here for a bit, and then, that's when Alex left, Cantu left, and I took his, and Doug took me.
Is there only one Saturday Sundays on three side and two side?
Yeah, I don't know why there's two on the one side. So me and Todd have it on the one side, and then there's one on each side.
Well, that's like Friday, Saturday, Sunday. There's only one on the 63 side for a t-shirt.
It's weird, 'cause like Thursday, Friday, there's more than one.
Madam Pro Chairman,
Yes.
you would agree that transcript's accurate, correct?
Except for some of the spelling of the names.
All
Yes,
right.
sir.
Aside from misspellings of names, it is correct, right?
Yes, sir.
We would tender to council defendants exhibit 27. and offer same at this time.
No objection.
Submitted.
You referred to the dispatcher throughout this section as she, correct?
Yes, sir.
I'm sorry?
Yes, sir.
And you were complaining that she was making you work that night, correct?
Just the way she was sending us like all the way across the city.
All right. So this patch that you're wearing, does it say only my district?
No, sir.
Do you get to complain to the dispatcher if she sends you to another district?
I didn't complain to her.
Okay, that's not my question. You agreed that the dispatcher can send you where?
Oh, yes, sir.
I'm sorry?
Yes, sir.
All right. And so whether you go to the 61 side, the 62 side, 63, if the dispatcher sends you there, you're supposed to be going there happy that you got a job, right?
I'm supposed to be going. Yes, sir.
All right. And you shouldn't be complaining if she cancels you, right?
I don't know, sir.
All right. So you weren't happy with the dispatcher that night, were you?
I wasn't happy. It's just some of the stuff that the distances, things like
You
that.
called her dumb, right?
No, I didn't. I said it's dumb.
All right. And you were complaining that you were canceled, right?
Yes, sir.
And you were complaining that she didn't like working dog watch, right?
I said I was tired.
All right.
When you work dog watch, you're physically tired.
And
You
you
get
said
tired.
the only reason you stayed there is because you have good weekends, right?
Yes, sir.
All right. So you waited for Salinas to take over the call, right?
We're there, and he texted me. He sent me a message to the cab saying that he was on the way.
All right. And you were sitting in your car. By the way, did you have that printed out?
The what?
The MDT message?
No, sir.
All right. You could have had that printed out and known what time he said he was on the way, right?
Yes, sir. I guess I don't know how to.
All right. So he sent you the message on the MDT while you were in the car, correct?
Yes, sir.
So if you were in the car at 12:51 through 12:57 or 58, that's when he would have sent you the message, right?
That's the time. I'm not sure exactly what time it was.
All right. And cars have what's called a GPS of all the red dots of all the cars in the section?
Yes, sir.
And you can find out where your fellow officer is, right?
Yes, sir.
So you knew that he was just around the corner on Pearsall Road and Sky Harbor, or whatever it's called, right?
Yes, sir.
All right, so you knew he was about to show up, right?
Yes,
You
sir.
were sitting in the car.
Yes, sir.
All right, and you were waiting for him to show up so he could take over the call, right?
Well, he had texted me that he was gonna take over the call. He had sent me a
Alright.
message, so yes, sir.
And so if he takes over the call, you don't have to work, right?
No, sir. I'm still helping with whatever he needs.
All right, but if he takes over the call, you don't have to write a report, right?
We need the reports are easy to write.
I'm sorry?
Reports are easy to write.
I'm sorry?
The reports, they're easy to write. I wouldn't have a problem writing a report.
All right, but you don't have to write a report if he takes over the call, right?
No, sir.
You agree you don't have to write a report if he takes over the call?
Yes, sir.
And if he takes over the call, you don't have to transport it, right?
No, sir.
You agree that the person assigned report responsibility transports the prisoner or the person being ED, correct?
Yes, most of the time. Yes, sir.
All right, so by him taking over the call, you wouldn't have to work, right?
No, I would go back in service.
I'm sorry?
I would go back in service, so yes, I would still have to work.
All right, but you wouldn't have to deal with Melissa Pettis, right?
I would still have to go back in service.
Okay, so if you go back in service, that means returning to your district, right?
To wherever she sent me.
All right, and where was your district that night?
I believe it was 6120.
All right, so that's about 15, 20 minutes away?
Yeah, maybe give or take.
All right, so if you did not have to transport Melissa Pettis, you'd be able to go back to your district, right?
Like I said, wherever she would send me.
All right, so can you see why a juror might think that I didn't get to this point was owing to you being lazy and neglecting your duties to take action?
No, sir.
All right. Now, if the call had actually ended, shouldn't someone initiate a new call if the call had ended?
No, sir.
All right. So you're saying there's not gonna be a new IDR?
For the same call we're on?
Yes.
No, sir.
All right, so the fact that you turned off your camera has nothing to do with the call continuing, right?
Excuse me?
The call continues whether you turn off your camera or not, you would agree?
So I turned off my camera when we end the call.
Okay, so did the call end or not?
At that point, we were walking back to our vehicles, so yes, it did end.
So they didn't create 2 new IDRs, did they?
I'm not sure. I don't think so.
All right, have you ever seen a second IDR created?
No, sir.
All right, so does it stand to reason that if the same IDR has everybody continuing on the call never really ended, did it? Even though you turned off your camera?
Like I said, so even if the call ends, if the other officer is still typing up the report, we're not gonna stay on the call just because the CAD is still on, the key card is still open. We'll clear, we'll turn off our camera, we'll clear, and we'll go back in service. Just because the officer is still on his call and typing up the report, we're not gonna stay on the, we're not gonna stay, we're gonna go back in service. We'll go back in service.
What you
So
just
just
said
because,
makes no sense to me, and I'll tell you why and ask you if you agree. You turned off your camera before you ever got back to your car, correct?
yeah, it's a couple, I wasn't too far from my car.
Okay. Do you have like supervision to see in the distance on your MDT?
Excuse me?
Do you have supervision where you can see from a distance your MDT?
Do you?
I'm asking you.
I don't know.
Okay. So, when you turned off your camera, you couldn't see your MDT, correct?
No.
All right. And so the key card was still open as far as you knew, correct?
Yes, sir. It's open to the handling officer, and everybody clears from it. It stays open.
All right. And you never saw on this IDR that the call was terminated at 1:20 when you turned your camera off, right?
If I never saw it, what? The actual,
The IDR never closed the call, did it?
it doesn't close the call. The officer closes the call on the actual key card. When they're done with the call, they close the call.
Alright, but on the IDR, the key card, on the computer, no officer, you, Salinas, or Ramos, closed this call either 5 minutes before 1:20 or 5 minutes after 1:20. You would agree with that?
Oh yes, we were walking to our car. We turned off our cameras and we're walking to our car. We were about to get inside our vehicles.
So nothing on the IDR indicated that the call had been closed when you turned off the camera, right?
Like I said, it's not going to indicate anything is closed until the officers, everybody clears from it, and the officer gives his disposition, then it'll close.
So can this jury conclude that the IDR is still open, the key card is still open, even though you turned off the camera at around 1:20?
Yes.
Alright, that's witness.
Everybody okay on the jury? Don't be shy.
Judge, to that point, I do have some analog visuals I need to set up, so I could use a few minutes. I don't mind doing it now in front of everyone, but it may take me about 5 minutes to get everything set up.
All right, in that case, let's go ahead and take a short break.
All right for the jury? Please be seated.
If you ever need a break, Mary, tell me too.
Pardon me?
If you ever need a break, you let me know.
Thank you, Jay. I'm good.
Anytime.
Chris, let me interrupt you. Just your exhibit, what's defense 21?
21, Salinas body cam 2.
Thank you. Salinas body cam, so-
I can do the same thing, like, this one.
Yes.
I can. I agree. Yeah.
When are you gonna get to the charges, like almost right away?
No. Well, I'm gonna get to criminal mischief right away.
Oh,
And I can do that, but I can do that over there.
okay, well, I'll pick Greg if you want. Turn me and say,
Okay.
you'll what me? Pick Greg.
Pick group, okay. You can do exhibit list and doing stickers?
Yes.
Okay, thank you.
All the discs have been marked. I just didn't number them yet.
I don't need, I won't do that one. Thank you. You want to sit on it? I'll sit. And after that will be. Response to disengagement. Yeah, 44. And that's it for exhibits. Good.
Now the middle siblings get their crack. The middle siblings
Yeah,
get their
that's
crack.
right.
I get, some leftover piece of turkey
Yeah.
skin after everybody else has already done it.
That's how it works.
Yeah.
That's how it works.
I'm gonna just go to the bathroom.
Yeah. But you notice, Christian, when you speak, it's authority.
What's that?
When you speak, it's authority.
You know,
Oh, you know?
I get in,
Feel it.
make the point,
You feel it.
get out.
You feel it.
You know?
It's on.
Yeah. You know?
Yeah.
It's nice and warm, everyone's nice and tired.
Yeah.
We've definitely not shown any more video.
Yeah.
Just
It's a change of pace.
adapting on the fly.
It's a change of pace.
Nice visuals. Go in.
You ready?
Candlesticks.
Already.
That was Newman, right, that was talking?
Yeah.
Entirety. That's okay. As well you should.
Judge, do you, have them stay here till I organize the exhibits, or how do you handle that? At the end of the day?
It's up to you. Generally, they always kind of stick around and help. But, yeah, it's always best.
I just wanna make sure they're all here.
It's always best. I'll definitely do that.
Okay, thank you, Judge.
kind of go look
Yeah,
at it?
yeah.
I'm interested. That's good. This is enough. I'm looking forward to next month.
You ready?
Ready?
I mean, I'm ready when the court's ready. Do you want a heads up
You
on
don't need to.
exhibits? I've got a bunch I'm gonna put in. Do you want me to tell you now, or just go slow as I go?
Just as you do them, I'd just like to know, just for the record
All right.
purposes, so I can.
So before this, I was in Medina County with a very nice lady by the name of Sherry Gentry. I don't know if stenographers know each other, but she
We
whipped
do.
me into shape for the last
Did
3
she?
years. She
Well, I
trained me.
need to call and thank her.
Yes, she's retired, but she still comes around. She's with her grandbabies now, but she was trial by fire with her. So I have utmost respect for you all.
Those smaller counties are tough.
Well, you know, yeah, they are. That's good. Manuals, discs. Tom? I think he went to go return some water.
Oh, okay.
Shouldn't be long.
Hi, I'm doing good.
I'm sorry?
Yeah, put him back. Absolutely. Makes sense. So right beforehand, let me know, and I'll make sure that we
I will. Thank you. You're welcome. Good catch.
I thought we were doing GWI.
Well, Armenia's about to fly out in 30 minutes.
Really? Nice. What a blessing. I'm jealous.
I know.
Those are the kind of things you don't want to miss out on.
Absolutely. I just got back from Greece.
Oh, did?
Yeah. We had a great time.
I've never been to Greece.
You should go.
Oh my gosh. That'd be great. Greece would be great.
I'm going to Argentina in December.
Yeah?
My son-in-law, they're all Argentinian, and my son-in-law is
I haven't gone out of the country. Years, decades.
Why?
Just out.
You don't like to go out?
No, just, I work all the time.
Yeah.
You know. It's been a long time. I'm gonna say since my 20s.
As we say, life is short.
Now, in the last 7 years, I've traveled a lot. Throughout the continent.
Oh, that's neat too.
I've done a lot of that.
A lot to see here.
Yeah.
Last question.
You're right, the time is,
As I'm doing this, guy, I've got an easel with a chart.
it's always the
Is it
right
okay
time.
that it partially blocks your view of the jury? That's fine. Okay.
I need to get that in my head.
It won't be for long.
My wife has been.
I've got one over there and one here. We'll go fast.
assumed would work for a very long time.
That's the way I was, and the last few years I've been a little more easier on myself.
I need to take your lead.
Yep, there you
For
go,
sure.
kid.
You guys ready? Yeah, y'all ready? David, y'all good?
We are.
Daryl? David, did you get the?
I did, I saw it. Thank you.
You're welcome.
Christian.
I'm gonna skip the video.
Okay.
I appreciate it. I'm gonna move this, I'll trip over it. Thank you, Ben.
This is your standard.
It is really.
All right for the jury? You may be seated.
All right, welcome back, members of the jury. As I mentioned to you before, please, if you need a break, don't hesitate to let me know. We can break at any time. All right, with that, defense, you're pro.
Thank you, Your Honor. And a few housekeeping items I want to offer at this time. I'll start with defendants' exhibits 28, 29, 30, 31, 32, 33, 34, and 35, and I'll describe each one. They've been tendered to the state for inspection. We're going to be offering 28, which is Officer Chernak's body camera video into evidence, 1 of 2. Defendant's exhibit number 29, Chernak's body cam video, disc 2 of 2. Officer Barcena's body camera video on a disc, that's defendant's exhibit 30. Officer Lamb's body cam video on that's defendant's exhibit 31 on the disc. Defendant's exhibit 32 is Officer Neri, N-E-R-I, his body cam video. Defendant's exhibit 33, Officer Rivera, his body cam video. Defendant's exhibit 34, Sergeant Robertson's body cam video on a disc. And lastly, defendant's exhibit 35, Officer Young's body cam video. We're tendering all those and offering them into evidence at this time.
And along as the representation is that whatever is contained on these discs is exactly what we gave you in discovery, and that there are no clips or any redactions or deletions.
I make that representation, yes, sir.
Then I have no objection.
All right, with that, defendants exhibit 28 through 35 are admitted.
Thank you, Your Honor. I will not be playing any videos right now. Got him. And then last quick housekeeping, a few more provisions we asked the court to take judicial notice of, penal code provisions. First, Texas Penal Code 28.03, or state jail felony criminal mischief. Secondly, Texas Penal Code 22.01B-2, the second-degree felony of assault of a peace officer. Texas Penal Code 39.03, official oppression. Texas Penal Code 7.01, parties to offenses. And Texas Penal Code 7.02, criminal responsibility for conduct of another.
All right, I'll take judicial notice of those.
Thank you, Your Honor. Good afternoon, Officer Ross.
Good afternoon.
I think we met on Monday, it's been a couple days now,
Yes, sir.
and I won't make you watch any more videos, so we're just gonna get right to the point, okay?
Yes, sir.
All right, so, when you are there at the scene that night dealing with Melissa Perez, we saw in the video several times now that when Officer Ramos shows up, she pretty immediately takes off running, right?
Yes, sir.
She doesn't just go to her apartment, it's a mad dash to her apartment, right?
Yes, sir.
Fast enough that her dog actually didn't make it into the apartment with her, right?
I'm not sure if the dog made it or not.
Okay.
Oh, he did it. Yeah, he did it.
Right, because I think we saw Officer Ramos pointing that taser at the dog.
Yeah, yes,
Kind
sir.
of pretending that he might tase the dog, right?
Yes, sir.
Okay. And so, just to ask you as an officer, someone sprinting at the sight of a second officer making the scene, that you'd agree that that's inherently suspicious, right?
Yes, sir.
Okay. And that makes sense for someone who's just admitted to committing a felony criminal mischief, right?
Yes, sir.
All right. Now, of course, at this time, Alfred Flores doesn't know any of this, right?
No, sir.
Villalobos doesn't know,
No, sir.
and Alejandro doesn't know yet, right?
No, sir.
They have no idea anything that's going on.
No, sir.
And so, as you just heard, the court took judicial notice of a few penal code offenses. Part of the academy in your training, you're taught the penal code, right?
Yes, sir.
So criminal mischief, assault on a peace officer, resisting arrest, official oppression, aggravated assault, those are all offenses you've been taught and trained on, right?
Yes, sir.
And I won't ask you to list the elements for me, okay? But we're gonna talk about those in a moment. So considering your observation of Melissa's state of mind from your perspective that night, through the evening, she actually communicated to you and other officers that they tried to arrest me. You guys tried to arrest me. You heard that on the videos, right?
I don't remember hearing that, sir.
Okay. We could play the video,
Oh.
if I represented to you that at some point she does say
Oh,
to
okay.
someone, they tried to arrest me,
Okay.
right?
Yes.
And if she did say that, which the videos would reflect, it sounds like she did know she was not free to leave, right?
Yes, yes, sir.
If she's saying they tried to arrest me, that's somebody who knows I can leave.
Yes, sir.
Right? Okay. Other things we saw her yell, tase me, shoot me, right? You remember hearing those things?
Yes, sir.
From her. So combining her verbal statements to all you officers and the assaults that we saw taking place, would you agree with me that it's clear to any reasonable officer that she is not coming out of that apartment room?
Yes, sir.
I mean, she could get an invitation from the President of the United States. She ain't coming out, right?
Yes, sir.
And so getting a warrant, in your experience, that's not really gonna make a difference with her, is it?
No, sir.
Right? With someone like her. So on that warrant issue, just quickly to touch on the bigger point. When someone's committed a felony, you don't need a warrant to go get it, right?
Yes, sir.
All right. And so she's admitted to committing that felony. She's now run, knowing you guys want to arrest her. That's what she said. That's hot pursuit in that moment, right?
Yes, sir.
And it's hot pursuit from both the felony criminal mischief, and yesterday Mr. LaHood talked to you about it's actually also a felony burglary of the building, right?
Yes, sir.
Okay. Whether or not that was your focus in your mind at that point.
Yes, sir.
Okay. So let's talk about criminal mischief. I'm gonna do that one over there. We'll do Defense Exhibit 36 as a demonstrative. If you can just take a look at this chart, Officer Rojas, and tell me, does this appear to accurately reflect the elements of criminal mischief as it appears in the penal code? Take your time.
Yes, sir.
Okay, all right. So let's walk through it here, just for demonstrative purposes. And we said this was 36, Tom?
36.
Okay. Go ahead and put the sticker on there. So, on defendant's 36, let's walk through what you know that night. We know it's on or about June 23rd of 2023, right?
Yes, sir.
And it's either 22nd or the 23rd, and you know from your training that it's just on or about, that's the important language here, right?
Yes, sir.
Okay, check, we got that element. You're a San Antonio Police Department officer, so obviously we're in Bexar County, right?
Yes, sir.
All right, and if we're talking about our suspect here, who's our suspect in the criminal mischief?
Ms. Perez.
Okay, so we'll do Melissa Perez. Okay, check, got that element. Based on what she told you, what she did was intentional and knowing, right?
Yes, sir.
All right. And we know she damaged or destroyed something, right?
Yes, sir.
And it was property, and what was the property she destroyed?
The fire alarm.
Fire alarm, okay. And how do we know how she destroyed it or damaged it?
Cut it somehow. I'm
Cut it
guessing.
with something,
Yes,
right?
sir.
And so if a 911 caller were to say, and you didn't hear the call, but were to say she was carrying around pliers, would that be consistent with the damage you saw?
Yes, sir.
Okay, so maybe the state would allege by cutting with pliers, right? All right, and then without the effective consent, who was the person that showed up on behalf of the apartment complex? Do you remember his name?
I don't, sir.
Does Kenji Uno sound right?
Possibly. I'm not
That's
sure
okay.
exactly what the
Fortunately, we have a document that's been mentioned a time or two, the IDR, and just see if you can get the name, because it's going to be important for the chart here. Let's look at page 3, just to help refresh your memory here. Do you see any mention of anybody that might be identified as someone for the property?
Yes, sir.
And what's that name?
Kenji Uno.
Okay, and that's Kengiuno, right?
Yes, sir.
And from that night, we know that Mr. Uno didn't provide consent to Melissa to cut those wires, right?
Yes, sir.
Not to state the obvious. And then we learned, albeit a little later after you got there, that the damage was more than $2,500 but less than $30,000, right?
Yes, sir.
And you know with the criminal mischief statute, the level of offense is determined by the value of the damage, right?
Yes, sir.
Okay, so do we have the elements of the state jail criminal mischief?
Yes, sir.
All right, committed by Melissa Perez.
Yes, sir.
Okay, easy enough, right? So, once she runs away from you, after committing that and admitting to that state jail criminal mischief, you talked about the hot pursuit. When she gets to that apartment, there's no home base rule, right?
Yes, sir.
Right? There's no all the other oxen free. You're continuously trying to get her, at least at that point, right?
Yes, sir.
And that's your job, right?
Yes, sir.
Chief McManus would expect you to keep doing that. We're going to try and get her with whatever reasonable means are available to us, right?
I guess it would be up to the supervisor at that point.
Well, at this point, you don't have a supervisor. It's you, right? You're
Yes.
Ramos. You got to make the decisions as far as the reasonable means available, right?
Yes, sir.
Okay. And as we've covered, I think a couple different ways, hot pursuit is an exigency, right?
Yes, sir.
Okay. And there are many kinds, but that's one of them.
Yes.
All right. So the state focused on the body cams on and off. And we've covered that pretty exhaustively. Would you agree with me that the amount of time between your camera being turned off and being turned on is less than a minute?
Yes, sir.
Okay. Pretty fast. It's not an hour, right?
Yes, sir.
Okay. And so that moment, that 20 seconds, let's call it, where the camera's off, Melissa doesn't know that, right?
No, sir.
And she doesn't get a fresh start. It's not a new encounter with police. You guys are still there at the scene, right?
Yes, sir.
All right. And we also see in the videos that have been covered when Officer Ramos is talking to Mr. Uno, the representative for the complex, that they've dealt with her before at that complex, right?
I believe it was Officer Salinas.
Was it Salinas?
Yes, I
Okay.
believe it was him.
Thank you for correcting me. So when Officer Salinas is talking to Mr. Uno, they learn, hey, she's actually burglarized the office not so long ago, right?
Yes, sir.
And had been arrested for it, right?
Yes, sir.
Okay, and that's on the video. And so, regardless, this quote-unquote termination of the initial encounter, Sergeant Flores doesn't know anything about any of this at this point, right?
No, sir.
Officer Villalobos doesn't know anything about what's going on, right?
No, sir.
Same with Officer Alejandro, right?
Yes, sir.
Okay, thank you. And as far as you know, Officer Ramos didn't share any of that with those three gentlemen, right?
Salinas? Salinas?
Ramos or
Oh,
Salinas?
yes, yes.
I was gonna ask you about both.
Oh,
Neither
okay.
of them shared what's gone on so far with any of these three officers.
No, sir.
And in fact, we've got now 10 officers at some point that show up to the scene here, none of them are given a full download of what's happened by you guys, right?
No, sir.
Okay. And so, without playing the video, we've talked a lot about Officer Salinas coming back to you and Ramos to say, we can go get her.
Yes, sir.
That's a turning point right there, right? And so, as far as you know, he's talked to Sergeant Flores at this point, right?
Yes, sir.
Did you know that when Sergeant Salinas talked to Sergeant Flores, Flores was actually at another crime scene, an aggravated assault somewhere else?
I'm not sure, sir.
But that wouldn't surprise you, right?
I mean, yeah, if he talks to him over there. He could have.
He could have been, right?
Yes.
Because sergeants, they're not like supervisors that sit at a desk at the station house, right?
Not necessarily. They'll move around the.
They can be out helping you guys.
Yes, sir.
Supportive capacity, investigating crimes, right?
Yes, sir.
So there's not this image of a sergeant sitting back at the station house waiting for his guys, his patrol officers to say, here's what I got, and offer resources. They're out doing the same job you're doing, depending on the supervisor, right?
Yes, sir.
It's fair to say there are some that are a little less adventurous, right?
No, yes, sir.
Okay. And so, a policy that you all have, this is maybe unique to SAPD. Night CID, what does CID stand for? Do you know by chance?
It's a night. I'm not sure exactly what it stands for, but
Criminal Investigations Division sound right?
probably.
Because there's the daytime, just Criminal Investigations Division.
Yeah,
and
they
then
all
there's
have
the night-
separate ones during the day, and at night, they deal with everything pretty
Right.
much.
They cover for the daytime guys.
Yes, sir.
Okay. And so, one of the policies that you guys are aware of is that, and when I see you guys as officers, patrol officers, is you can call night CID to verify whether whatever it is you've got is maybe a felony, right?
Yes, sir.
And so calling someone like, let's say, Detective Thornton would be helpful to tell them, here's the damage, here's the dollar amount, can you refresh me on what I've got? They can tell you you've got a felony.
Yes, sir.
Okay. And then as a follow-up to that, part of the policy and procedure is you need to let your sergeant know if you're gonna make a felony arrest, right?
Excuse me.
You need to let your sergeant know that you're gonna make a felony arrest.
Yes, I've talked to him. Yes, sir.
Okay. Give him a heads up. This is what I've got, this is what I'm doing, get the green light or not, right?
Yes, sir.
Okay. And it wasn't you that did that night, it was Officer Salinas that did that.
Yes, sir.
Okay, because it was he took over the case, it was in his area, right?
Yes, sir.
All right. Would you agree with me that there's no reason for you to mute your body cam when you call a sergeant just to notify him that you're gonna make a felony arrest? Not really a good reason to do that, right?
No.
Not really, right?
Yeah.
Because sometimes, and I've seen this as a prosecutor over the years, you can mute if it's for tactics, you guys say, right?
Yes, sir.
You can hold your body cam and say muting for tactics, bloop, and you mute it, right?
Yes, sir.
The calling night CID or sergeant to get this verification, that's not tactics, that's pretty plain procedure, right?
Yes.
Okay. And so, unless you were there for the call, you can't tell this jury whether all Salinas told Sergeant Flores was, Melissa, this woman committed a felony. You don't know whether it was any more or less than that, right?
Yes, I
Okay.
know exactly what he told him.
What we do know, not to belabor the point, but as far as the key card's concerned, there's not a whole lot of extra detail in there that Flores would be able to refer to in a conversation.
No, sir.
Okay. Salinas doesn't update the key card, right?
I'm not sure. I don't think so.
Having looked at it, you didn't see a lot of notes from
No.
Salinas? Okay. And, of course, Ramos doesn't look like he did many updates to the key card either.
No, sir.
So, if Officer Salinas concealed the contents of his conversation by muting his body camera, and you didn't hear it, there's no way for this jury to know right now whether Sergeant Flores had all the information he needed at that time. Is there?
Yes, sir.
You'd agree that there's no way for them to know right now?
Oh, yeah, I agree.
Okay. So, a couple minutes into the video, call it around 1:39. There's kicking at the front door. Officer Salinas now does 10 what I think is described as mule kicks on that door. You remember that, right?
Yes, sir.
You didn't consider that to be an attempt at an illegal entry, right?
No, sir.
And Mr. LaHood kind of made the point yesterday, if it was illegal, that would be a attempted burglary of a habitation, right?
Yes, sir.
And so, of course, you standing there and Ramos standing there, you guys there, you don't think you're committing felonies?
Yes, sir.
Okay. And even if someone were to tell you, you gotta break into this house, if you know it's unlawful, you can't follow unlawful orders, right?
Yes, sir.
Regardless of whatever the policy ramifications will be, you know, if I'm following the law, I'm good, right?
Yes, sir.
All right. And as far as you know, Sergeant Flores didn't tell any of these guys to go kick that door, right?
Yes, sir.
Ramos actually kicks the door as well at that point, right?
Yes, sir.
And that was not a criminal offense, right?
No, sir.
Now, the state's position, I think it's become obvious through questioning, is that Melissa made it to home base, and there's no right to enter that apartment. You'd agree with me that that's kind of the theme here?
Yes, sir.
All right. Even though you did have a duty to arrest her based on the felonies, right?
Yes, sir.
Okay. So if that's true, let's walk through another chart. Official petition. What number is that? 39? Probably haven't looked at this offense too many times, but take a look here and see if that looks right based on your recollection of the penal code for the official oppression offense.
Yes, sir.
Okay, so we'll use this as a demonstrative. This is Defense Exhibit 39. This is a statute the court took judicial notice of, so let's run through this one. Same thing, different character though. So, obviously we know, it's still June 23rd, on or about the 23rd, Bexar County, we know that. So let's talk about, let's first do Officer Salinas. He was there, right?
Yes, sir.
Okay. We're talking about the treatment that Melissa Perez is subjected to, right? If we're talking about official oppression.
Yes, sir.
Okay. Okay, so we've got our complainant. Would you agree with me that trying to get into her apartment is Officer Salinas trying to make an arrest, detention, search, or seizure? You'd agree with that, right?
Yes, sir.
All right, so those mule kicks, those 10 kicks, that's him doing that. That the officer knew was unlawful, that's the question, right?
Yes, sir.
And Officer Salinas here was acting under the color of his employment as a peace officer. He was acting as a police officer, right?
Yes, sir.
And if he did that, it'd be a Class A misdemeanor. If you remember from classes, still come to felony district court though, right?
Yes, sir.
Because it's police officers. And so here, knowing that that conduct was unlawful, like you said, Salinas trying to get into that apartment to go get Melissa was not unlawful, right?
No, sir.
And Officer Ramos trying to do the same thing. Good grief. Okay, let's try this again. Ramos trying to do the same thing. He didn't know it was unlawful, right?
No, sir.
Because it wasn't unlawful, right?
No, sir.
Okay. Because if it was, you're familiar with the concept of parties in criminal penal code, right?
Yes, sir.
Where if Mr. Nisbet and I go out and commit a crime together, we help each other out in some way. Maybe I'm the primary actor, he just assists me. He can be just as guilty as me. Bank robbery, right? He drives me to the bank, I go in, I go rob the bank. He's a getaway driver in our British car, the steering wheel on the right. Not in Canada, right?
No.
Okay. So even if he's just the getaway driver, he could be just as guilty as me, right?
Yes, sir.
And that could even apply to officers if they were acting together to commit official oppression, right?
Yes, sir.
And so if what they were doing was in fact unlawful, that would get you in the hot seat too, right? Because you're there helping.
Yes, sir.
Okay. And going back to those kicks in the door, you all learned that she'd actually wedged a chair under that doorknob inside, right?
Yes, sir.
So, and we'll touch on this in a moment, even if you'd gotten a key, let's say, there's no way you're getting in that door, right?
No, sir.
Not without a ram or some heavy duty equipment that none of you guys have.
Yeah.
Okay. So, a few minutes later, and before I move on, still at this point, Alfred, Nathan, and Elazar don't know any of this that's going on, right?
No, sir.
They're out somewhere else in the district doing their thing, policing the streets, right?
Yes, sir.
Honoring their duty to preserve peace and prevent crime, right?
Yes, sir.
Like you're there doing. By 1:40:56, we now know that Salinas had Melissa at gunpoint because he had just gotten assaulted by Melissa Perez, right?
Yes, sir.
And he announces as much, right?
Yes, sir.
Now, Sergeant Flores, of course, didn't tell Officer Salinas to hold her at gunpoint, right?
No, sir.
Salinas made that decision on his own. Same for Villalobos and Alejandro, they're not even there, right?
Yes, sir.
Okay. At that moment, was Salinas committing an offense? Holding her at gunpoint?
No, sir.
It wouldn't be official oppression, right?
No, sir.
A seizure by holding someone at gunpoint, not an offense, right?
No,
And
sir.
I agree with you in these facts, right?
Yes.
I'm not disagreeing with you, but he was not committing official oppression at that point.
No, sir.
And why is that?
Because she swung that hammer on her, towards him.
Yeah, she assaulted him, right? And I think we can go ahead and let's jump to that chart.
Ag or regular?
Okay. Forty? Yeah. Okay, I think you know what's coming next. Take a look while I'm walking here.
Yes, sir.
These elements look accurate to you?
Yes, sir.
Okay, all right, so we've now got State's Exhibit 40 as a demonstrative.
That's a defendant, right?
Thank you, Judge. It is in fact a Defendant's Exhibit 40. Old habits. Okay, Defense Exhibit 40. On or about, call it 6/23/2023, Bear County. The person who assaulted Officer Salinas, like you just testified, was
Melissa Perez.
Melissa Perez. And what she did, was it intentional or knowing?
Intentionally.
Okay,
What did you say?
Intentionally.
perfect. And by swinging, hammer like Defense Exhibit 11 here, like this, she didn't make contact in that moment, right?
No, sir.
But by swinging it, that's a
Threat.
threat, right? And it was a threat of imminent bodily injury, because if she had connected, that would have done some serious damage to Officer Salinas, right?
Yes, sir.
So here, we're talking about Salinas. And he's not just a public servant, he's specifically a
Law enforcement officer.
officer, right?
Yes, sir.
And being an officer, when a public servant is a third-degree felony, when it's a cop, when someone aggravatedly assaults an officer, it's a second-degree felony, right?
Yes, sir.
Or first degree felony?
It's
First,
first.
thank you. It is a first degree
First.
felony. They keep changing these laws and making it more serious to assault officers. Okay. And it's important, of course, that we're talking about an officer who's on duty, right?
Yes, sir.
And we have here by swinging a hammer
Yes,
at
sir.
or in the direction of Salinas. And you probably know where I'm going with this. Would you agree that this could be a deadly weapon?
Yes, sir.
Especially when swung at somebody's head, right?
Yes, sir.
Could cause serious bodily injury and even kill someone.
Yes, sir.
And as you pointed out, it's on my chart. Should look at the bottom. First degree felony, okay? So that's what Melissa Perez has done at this point, right?
Yes, sir.
So just so we're keeping track, we've got a state jail, criminal mischief, state jail for a building. She's also evaded arrest or detention. Now we have an aggravated assault on a police officer, and like you just said, that's why Officer Salinas was allowed to draw down on her, hold his gun.
Yes, sir.
Makes it A-okay, right? Even though Officer Salinas had jumped into her patio and went to try and unlock that door, right?
Yes, sir.
The fact that he was there doesn't mean that he has to allow her to assault him with that hammer, right?
Yes, sir.
Okay. At this point, we've referred to as an E-tone. Is that emergency tone?
Yes, sir.
How does that get activated? If you had to do it?
We have a button on our either lapel mic on our radio.
Very easy to do, very important.
Yes, sir.
It's
the red
important you can
button.
do it quickly, right?
Yes, sir.
And that tells everyone in the area
That,
who's in trouble.
yes, sir.
Okay. All hands on deck.
Yes, sir.
And so Mr. Cifuentes asked about the GPS with all the red dots. We would see them all now descending on wherever that officer is that hit the E-tone.
Yes, sir.
Okay. So at this point, would you agree with me that's the first new piece of information that Sergeant Flores has gotten now, since getting a call from Officer Salinas, whatever the contents of that call were?
Yes, sir.
So that new piece of information, officer in trouble, same information that Villalobos and Alejandro would have gotten at that moment as well, right?
Yes, sir.
So just to recap, we know now about the variety of offenses. These officers now know if they looked at the key card, we got someone possibly intoxicated, right? They've evaded, and now we of course know that we have this felony assault on an officer, and it's all hands on deck. The call's really been blown up at this point, right?
Yes, sir.
Rightly so, right?
Yes, sir.
And so after that hammer, we then have another instance where Melissa does something to Officer Salinas. Do you remember what that is?
Can you say it again? I didn't hear you.
That's okay. Kind of word salad in there. After the hammer swing, was there something else that Melissa did to Officer Salinas?
Oh, through my candle.
Your candle, right?
Yes, sir.
Let me show you what's been marked as Defendant's Exhibit 41 for demonstrative purposes. Does this generally depict about the size and shape of the candle that Melissa threw that night?
Yes, sir.
Okay. So just for demonstrative purposes, now after the hammer assault, she misses. Salinas gets back, got her at gunpoint. Now she grabs one of these guys, like Defense 41, off her counter. And we saw in the video, she comes to the window and she throws it at Salinas, right?
Yes, sir.
And hits him.
Yes, sir.
And I think you may remember from the video, you can hear him grimacing. Ah, that hurt.
Yes, sir.
Hurt pretty bad, right? I mean, getting hit by this would hurt pretty bad.
Yes, sir.
Especially from a close distance.
Yes, sir.
Okay. So, 37, thank you. I'll show you states 37.
37.
I'm sorry, defendant's 37. Did I mess it up there?
Official person's 39.
Yeah. We're skipping around a little bit, sorry about that. So 37, elements look right to you?
Yes, sir.
Okay. Thanks to you reminding me, we know this is a secondary felony. Okay, so let's do this quickly. On or about June 23rd, 2023, Bexar County. We obviously know we're talking about who committing the assault?
Melissa Perez.
Melissa Perez. And did what she do with that candle, was it intentional, knowing, or reckless? Any of those three?
Intentionally.
Okay. And do we know whether it caused bodily injury to Officer Salinas?
Yes.
As far as the penal code definition goes, right? Because for bodily injury, all we need is?
Pain.
Pain, that's right. Salinas. And Officer Salinas is obviously a peace officer, right?
Yes, sir.
Which is a type of public servant, a peace officer for the statute, right?
Yes, sir.
And was he discharging his official duties?
Yes, sir.
And how is it that she caused that pain?
Candle.
Candle. Second degree felony. Okay, so we'll add that to the list of offenses that Melissa has committed at this point before Alfred, Elazar, and Nathan have gotten there, right?
Yes, sir.
They're not there, they don't know any of this, right?
Yes, sir.
Other than officer in trouble. Okay. And there's no way for them to know, out of fairness.
Yes, sir.
You're not calling it, there's not a group chat, there's not a WhatsApp chat where you're doing a live update, you're dealing with the person in the moment, you don't have time to give everyone an update constantly, right?
Yes, sir.
Okay, out of fairness to you. So, 141, not only had Officer Salinas pulled his gun, Officer Ramos actually drew down on her as well, right?
Yes, sir.
And if the state's theory held any water that Melissa could defend her property, well, that would be an offense for them to pull their guns on her, right? If that was true.
Yes, sir.
Okay, but we know it's not, right?
Yes, sir.
Because Ramos is defending his fellow officer, which is allowed under Texas Penal Code 9.33, defense of third person, right?
Yes, sir.
All right. And of course, Flores didn't tell anyone to pull their gun out, right?
Yes, sir.
Elzor and Nathan didn't tell anyone to pull their gun out either, right?
Yes, sir.
So, then we get Ramos jumping into the patio. That's not an illegal entry, right?
No, sir.
It's not a criminal trespass,
No, sir.
even though they didn't have consent or permission from Melissa, right?
Yes, sir.
And why is that? What is it that Ramos and Salinas are trying to do in that moment?
Take her in custody.
They are, right? But Flores didn't tell them to jump the railing to go take her into custody, right?
No, sir.
Okay. They decided that on their own because that's a reasonable way to try and get at her when she has wedged that door shut with a chair, right?
Yes, sir.
All right. We hear Ramos at 141:52 verbalize threats to Melissa saying, "You're gonna get tased." You remember hearing that, right?
Yes, sir.
She says, and I'll censor it, "I don't give a F, tase me." Right?
Yes, sir.
Now, none of our clients here have any idea that Melissa is at this point inviting assaults by the officers, right?
No, sir.
Still not there, right?
No, sir.
Just a minute, not even a minute later, Ramos then pulls his gun again. He goes from less than lethal, the taser, to now the firearm. But that's not an aggravated assault by him, right?
No, sir.
Because if a regular person does that, let me get another demonstrative here. Sorry, it's not 45?
Yeah.
Go.
Yeah.
45?
45.
Just as a demonstrative, so the bailiffs know, plastic gun, we're good, right? Kind of looks like a type of service weapon, right?
Yes, sir.
Glock. So when somebody pulls a gun and points it at somebody, that's a threat, right?
Yes, sir.
Can be.
Yes.
And so if you respond to a call, I call you, or Tom calls you, and Tom says, "Christian pointed his Glock at me," that would be an aggravated assault with a deadly weapon by threat, right?
Yes, sir.
Because a gun is definitely a deadly weapon, just like that hammer can be, right?
Yes, sir.
All right. And of course, we know Officer Salinas and Ramos, they weren't charged with any wrongdoing at all for that night, right?
I don't know. I don't think so.
As far as you know.
Oh, yeah, as far as I know, no.
Because they weren't doing anything wrong, right?
Yes, sir.
They're doing their job. So, another minute later, I think you may, tell me if you heard Salinas say, "I don't want to push the issue, she has a hammer." Remember that?
Not sure.
Okay. Now, if he said that, assuming the video says that, okay? That's an acknowledgement that the hammer is an enhanced threat to you guys, right?
Yes, sir.
Regardless of what policy is or what you might have been able to do in the past, that hammer is an important factor in the totality of the circumstances that you all are working with that night, right?
Yes, sir.
I think you probably know where I'm going with this. Sergeant Flores still doesn't know any of this yet, right?
Yes, sir.
Doesn't know that she's got this hammer and plenty of other candles in that apartment to assault officers with. He doesn't know any of that.
Just whatever you put on the radio.
Exactly right. Officer in trouble, in talks, evaded, criminal mischief. That's all he knows, right? We've got somebody that's assaulted an officer. That's all he knows.
Yes.
Okay. Same with officers Villalobos and Alejandro, correct?
Yes, sir.
Now, let's say you were out in the street, hypothetically, and someone is attacking you with that hammer, okay? I won't do it. But let's say I am less than 21 feet from you. We'll talk about that. I'm coming at you with a hammer. What are you using on your duty belt to deal with me in that moment? I'm running at you with the hammer.
My firearm.
You're shooting me, right?
Yes, sir.
No question. Could you actually stand up for me for the jury? And could you introduce the jury to all the great gear you've got on your duty belt there? Let's walk through it, starting on the right here. You've got handcuffs, right?
Yes, sir.
And handcuffs, you're actually trained, you can use them as a weapon, right?
Can.
Not ideal.
Yeah.
But if the situation calls for it, if you hold them, you can actually do some damage with those handcuffs, right?
Yes, sir.
And what do y'all carry? Smith & Wesson
Yeah.
handcuffs?
It's whatever.
The gold standard, right?
Yeah, whatever.
Next, what do we have on your belt there?
Firearm.
Okay, and there's an empty slot. What goes in there?
Flashlight.
A flashlight, okay. Can the flashlight be used as a weapon depending on the circumstance?
Yes, sir.
Probably shouldn't though, right?
No.
Okay. Firearm, what kind of firearm do you carry?
Smith & Wesson.
Okay, and what's the next thing that you carry?
A soldier baton.
A baton?
Yes, sir.
Is it some type, an asp?
An asp, yes, sir.
Is that one of these guys where you whip it and it flies open?
Yes, sir.
You can do some pretty serious damage with those, right?
Yes, sir.
And that's important for you to be able to protect yourself.
Yes, sir.
Let's go to your left side. What else are we working with here?
Taser.
Taser, okay. Less than lethal, right?
Yes, sir.
And what kind of range is a taser effective at?
This one's probably like 30 feet.
Up to 30 feet, right?
Something like that, around there.
Pretty hard at 30 feet though, right?
Yes, sir.
Because when you shoot that taser, there's prongs that go out that have to connect with the human body for it to really work, right?
Yes, sir.
I'm not a physics guy, but the electric circuit has to close, right, for it to really do its job,
Yes, sir.
right? But if I'm this close, taser's no good, right?
No, sir.
Not really, right? Okay. What else do we got? Anything else?
That's it.
You carry pepper spray ever?
No, sir.
Is that an option for you guys to carry?
Yes, sir.
Okay. All right. Thank you. You can have a seat. And so, let's say now, instead of just right here, there's a glass door between us. Wood frame around the outside, but glass panes. And I've got this hammer. You're still using that gun to stop me, right?
Depends if I feel it's gonna life is in danger.
That's exactly right. If you feel that your life is in danger and it's reasonable that you feel that way, let's say I'm this close and all that's separating us is a glass door, and you think I'm going to get you or maybe a guy standing next to you, you're going to use that gun to take me out, right?
Yes, sir.
Now, you don't want to, right?
No, sir.
No officer wants to, right?
No, sir.
Because when you go to roll call, before you go and hit the street, one of the things you guys, I'm sure, talk about is everyone goes home tonight, right?
Yes, sir.
That's a common theme for sergeants to tell their officers, hey, you have a duty to go out and preserve the peace and stop crime when you can, but you have a right to go home, right?
Yes, sir.
Number one priority. And so officers get a lot of latitude as long as you're being reasonable and you're acting reasonably and out of necessity, you're going to be okay, right?
Yes, sir.
You shouldn't end up in those seats as defendants, right?
Yes, sir.
Okay. So, jumping to 144, I think it was you that said slow everyone down after the e-time.
I don't remember.
One of you said
Yeah,
that.
it's the Amir sitting us. I don't
Okay.
remember exactly who it was.
And so if one of you said that, why are you saying slow everyone down?
Because she was inside the apartment, and we were able to get away from there. So there was no need for them to be driving at the speed to get there.
That's right. So Ramos and Salinas have now been able to escape from the patio. We want to slow everyone down because it's dangerous for everyone to come flying to the scene. They're speeding, running lights, flying through traffic, right?
Yes, sir.
Okay. So at this point, Sergeant Flores, Officer Villalobos, and Officer Alejandro know about a couple of the offenses she's committed, that she may be intoxicated, has run from officers, and has assaulted an officer in their area. That's what they do know, right?
Yes, sir.
But they don't know that Officer Ramos has been taunting Melissa Perez, right?
No, sir.
They don't know that Officer Ramos called her a gang member, right?
No, sir.
They don't know that Ramos is making jokes about her looking like Prison Mike from The Office. They don't know any of that, right?
No, sir.
They don't know that she got hostile when you question her about her mental health, right? They don't know that.
No, sir.
And that was a good thing that you asked her about it, because as an officer, you need to learn everything you can, right?
Yes, sir.
They don't know that she's claimed to own the complex.
No, sir.
They don't know that she's claimed to be Elvis's daughter. They don't know that Fireman Hudson thought she might have mental health issues, right?
No, sir.
They don't even know that she's locked herself in the apartment, do they?
No, sir.
No way for them to know. And no one told, as far as you know, no one told Sergeant Flores in particular that anybody wanted to go into her apartment to go arrest her, as far as you know.
No, sir.
Okay. Sergeant Flores in particular, but the other guys as well, they don't know that Salinas got assaulted because he was halfway through Melissa's window, right?
No, sir.
They don't know that Ramos jumped the railing onto her property, right?
No, sir.
But they also don't know that Ramos threatened Melissa with deadly force, pulling that gun, right?
Excuse me?
They don't know,
No,
none
sir.
of them know that,
No,
right?
sir.
And so Sergeant Flores and Officers Villalobos and Alejandro, they don't know that Ramos in particular and Salinas have just swatted this hornet's nest that is Melissa Perez and gotten her all agitated at this point. They don't know that, right?
No, sir.
But they've been told, hey, come help me out with these hornets.
Yes, sir.
Okay. Melissa says to you all, this ain't my first rodeo, right?
Yes, sir.
When you're dealing with an intoxicated subject out in the world, and somebody tells you this ain't my first rodeo as they're resisting arrest by you, what does that tell you about that person's experience with law enforcement?
A lot of experience with them.
Yeah.
Yes.
And they're not afraid,
Yes, sir.
right? Fights on, fair to say.
Yes, sir.
Of course, once again, Flores, Villalobos, and Alejandro don't know any of this yet, right?
Yes, sir.
And touching on that resisting arrest, got me a chart. 38. As a patrolman, you're definitely familiar with the offense of resisting arrest, right?
Yes, sir.
These elements look accurate to you?
Yes, sir.
Okay. And so defense 38, get that right by the end of this trial. Marker. Defendant's 38. In a hypothetical prosecution of Melissa, we know the date, we know the county, we know, I'm going to make this faster, MP, Melissa Perez, intentionally, right? What
Yes.
she's doing is intentional.
Yes, sir.
Is she preventing or obstructing her arrest?
Obstructing.
Obstructing, yes. Of herself. And while she's doing that, is she using any deadly weapons?
Yes, sir.
And what deadly weapon?
A hammer.
And is the person or the people that she's doing that, are they officers or people acting at an officer's direction?
Yes, sir.
Okay? And everything she's doing is to resist, prevent, or obstruct the arrest, right?
Yes, sir.
Okay. And when she does all that, it is a third-degree felony.
Yes, sir.
Okay. We've added that to the list of felonies that Melissa has committed before any of these three guys even get to the scene, right?
Yes, sir.
Okay. 147, finally, Officer Villalobos gets there. And we hear on the video, we hear him say, he or someone says, what do we got, right?
Yes, sir.
And that's pretty typical. Officer arrives, there's other officers there. Let me get a debrief or a download from someone on what do we have, right?
Yes, sir.
Because at this point, Villalobos doesn't know about the taunting and the comments and the mental health and all this stuff. That's why he's asking, what do we got?
Yes, sir.
Okay. And you'd agree with me, all that information would be very valuable for Officer Villalobos to have once he arrives at that scene.
Yes, sir.
In fact, he doesn't even know at this point that there's a bedridden old man in that apartment. Not at that point yet, right?
No, sir.
Also valuable information for him to have, right?
Yes, sir.
think on the video, we hear you talking to someone about, and the statement I think is, talk to Sarge, she cut off all the wires to the alarms. Do you remember saying that?
I think to Salinas.
To Salinas?
Yes.
Or were you telling someone else because that's what happened when you were with Salinas earlier?
I'm not sure. I'm not sure exactly when.
That's
I'm not
okay.
sure
That's
exactly
all.
when it happened.
It's not that important, but if you were telling someone, talk to Sarge, she cut off all the wires to the alarms, that's at least generally a true statement, right?
Yes, sir.
Whether or not it was you or Officer Salinas that talked to Sarge, Officer Villalobos wouldn't know,
No, sir.
right? Okay. Now, at that point, we can see in the video, you'd agree that Officer Villalobos is very calm,
Yes, sir.
very polite.
Yes, sir.
Nice guy.
Yes, sir.
No weapons drawn, no indication that he is out to get in some trouble tonight, that night, right?
Yes, sir.
He's honoring his duty to preserve the peace and prevent crime.
Yes, sir.
All right. At this point, we still don't have Alejandro, we still don't have Flores on scene. He asks, she committed a felony? With a question mark inflection, you remember that?
I don't, sir.
Okay, and if it's on video, we can refer to that, right? Do
Yes,
you
sir.
remember hearing him say on the video, we can't get her?
Excuse me?
We can't
I
get
don't
her?
remember.
Him asking, what we can't get her?
I don't remember.
Okay, fair enough. Do you remember hearing Officer Ramos telling Officer Villalobos, we tried kicking the door? Does that
Yes.
sound right?
Yes, sir.
Okay. And Villalobos asked, how about the window? Sounds right,
Yes, sir.
based on the video. And out of fairness, I think you were making this point with Mr. Cifuentes, you're not there at the railing the whole time, right?
Yes, sir.
You're moving back and forth. We got several windows we need to keep track of to contain this thing, right?
Yes, sir.
All right. And at this point, when Ramos is telling everybody about what efforts have been taken, we've got multiple officers on scene, right?
Yes, sir.
Where at some point we got 10 plus.
Yes, sir.
No one at any point says anything about, you did what? You tried to do what? Right?
No, sir.
No one's questioning the idea that we are going into the apartment to take her out, right?
No, sir.
Because it's a good idea, right?
Yes, sir.
Okay. Now, we heard Villalobos ask if the door's locked. Did y'all check it? Someone says, watch out, she's got a hammer, right?
Yes, sir.
Because that's very important for Villalobos to know, isn't it?
Yes, sir.
If he's gonna jump that railing and try and unlock that door, he's gotta know she's got a deadly weapon and she's ready to use it, right?
Yes, sir.
All right. And you may recall from the video, Villalobos says, we're pretty much to go in there, she committed a felony. Remember that statement, right?
Yes, sir.
And that's a true statement, right? Got a felony, committed on view, we can go get her, right?
Yes, sir.
Okay. And so, I won't recap all the things he doesn't know, I think that point's been made. We hear Villalobos at 1:50:24 say, she doesn't have the hammer right now, does she? That's what the video shows, right?
Yes, sir.
Okay. And at this point, now Officer Alejandro has made the scene. So everything that's happened before Alejandro got there, he didn't know, right?
Yes, sir.
Couldn't have known.
Yes, sir.
Okay. I think there's more comments on the video about she committed a felony. It seems clear, I think to anyone watching the video, all the officers are keying in on the fact that this woman has committed and really multiple felonies, right?
Yes, sir.
Because that's what gets an officer's attention. Those are the people you're really most worried about getting off the street. Other than DWIs, those are misdemeanor felonies, right?
Yes, sir.
We want to prevent the greatest harm possible. So now, at 1:50:35, just a little bit later, Sergeant Flores finally makes the scene, right?
Yes, sir.
He's a little later to the scene, as he was at maybe another aggravated assault call himself, right?
Yes, sir.
At that moment, as far as you saw yourself that night or have seen on video, you haven't seen anybody tell Sergeant Flores that there's a mental health concern, right?
I'm not sure if anybody talked to him before that.
Okay.
When he
But
got
as
there.
far as you know,
Oh, yeah, as far as I know, no.
and as far as the videos that you've seen show, nobody goes up and tells Flores, we may have a mental health issue here, right?
No, sir.
Okay. And all I'm asking is as far as you know, so just to be fair. He's not told, as far as you know, that anybody wants to emergency detain him, right?
No, sir.
He's not told that anybody's already threatened her with force, right?
No, sir.
No one's told him that anyone's threatened her with deadly force, right?
No, sir.
And no one's told him that anybody jumped on the porch, Salinas or Ramos, right? As far as
No,
you know.
no, sir.
And that Salinas actually crossed that threshold into her apartment when the attack happened. He doesn't know that yet.
No, sir.
Okay. He also doesn't know that that door is wedged shut with a chair, right?
No, sir.
Okay. And nobody, as far as you know at that moment, has told Flores anything about her having been in this apartment this whole time.
No, sir.
I won't ask all the same questions again, but that series of questions asked to officers Villalobos and Alejandro, you didn't hear anybody share any of those details with them either, right?
No, sir.
We hear in the video at 150:54 that Sergeant Flores declares that they don't need a warrant because she's assaulted one of his officers, right? He's talking to her.
Yes, sir.
That's true, right?
Yes, sir.
Okay. And so, just a minute later, we hear Officer Ramos tell Sergeant Flores there's an old man in there that's bedridden, right?
Yes, sir.
We heard that on the video. So now at this point, at 1:51 a.m., Sergeant Flores for the first time learns there's a bedridden man in that apartment, right?
Yes, sir.
And he has no information to the contrary, right?
No, sir.
Okay. And evidently that didn't come up with the phone call by Officer Salinas, right?
No, I'm not sure.
Right, well, based on Sergeant Flores' reaction to being told, oh, there's somebody else in there, it sounds like he had not heard that before, right?
Yes, sir.
Okay. We see in the video that Sergeant Flores leaves to go talk to maintenance, Mr. Uno, because he's looking for a key, right?
Yes, sir.
But because he doesn't know about that chair at the front door, that key's not gonna do anything, is it?
No, sir.
Right? And a warrant with a key, not gonna do anything for getting into that apartment, right?
No, sir.
Another minute later, 1:52, another Salinas, Maria Salinas, who's also at the scene. You remember her there, right?
Yes, sir.
She actually gets Melissa Perez at gunpoint, doesn't she?
Yes, sir.
But she didn't commit any kind of offense by doing that. She's protecting fellow officers, right?
Yes, sir.
In fact, we hear on the video say she almost hit you. Do you remember that?
Yes, sir.
We can see in the video, and I think it was paused at this point, because this is when Villalobos is now over the railing. He's managed to unlock that door. He has his foot wedged up against the bottom of that door because he thinks he's successfully unlocked it, right?
Yes, sir.
So if Maria says she almost hit you, dude, she's talking about Villalobos almost getting hit with the hammer just like that, right?
Yes, sir.
In the head, right?
Yes, sir.
What do you think that could have done to Officer Villalobos if she connected?
Serious body injury.
Could have killed him too, right?
Yes, sir.
Okay. About 30 seconds later, we hear Officer Alejandro say, there's no point in tasing her because how are we gonna go hands-on? What does that mean to you as an officer? What's he communicating to his fellow officers?
Can you repeat it again?
Yeah, absolutely. If Alejandro says to his fellow officers, there's no point in tasing her because how are we going to go hands-on? What's the concern he's expressing?
Probably because she was inside.
Right. So even if we manage to get those prongs through the window, even if, you gotta get to that person quickly, right?
Yes, sir.
Because a taser, it's not like on TV where they, person turns into a 2x4 and falls over, right?
If they get hit.
It can be, right?
Yeah, it can be.
If you really connect and you get good contact, it can take someone out like that, right?
Yes, sir.
But even if not you yourself, I'm sure you've seen instances where the taser didn't quite connect that well, right?
Yes, sir.
And if someone's intoxicated and agitated and going through an episode, some people aren't even affected by it, right?
Yes, sir.
That's why it's important to be able to go hands-on immediately and deal with the threat, right?
Yes, sir.
So the taser at this point, not an effective measure of force, is it?
No, sir.
Aspeton wouldn't be effective in this particular scenario, right?
No, sir.
The handcuffs as a weapon wouldn't be effective, right?
No, sir.
Really, if you're on the business end of a hammer, the only effective tool on your tool belt is your gun in that moment, right?
Yes, sir.
So another minute later, Alejandro asks, does Sarge know it's unlocked? He's talking about that back door, right?
Yes, sir.
No one's communicated that to Sergeant Flores. Still, no one is saying anything about, whoa, time out, what are we doing, why are we going in this apartment, right?
Yes, sir.
Everybody's on board with this plan. 10 plus officers, right?
Yes, sir.
And there are other sergeants there too, right?
Yes, sir.
Because it's not an unreasonable plan, right?
Yes, sir.
And so if everybody's on board with this plan, is encouraging it, is assisting it, is aiding it, like a party might be if it were an offense, for whatever reason, Chief McManus and this district attorney's office have only singled out these 3 officers, right?
Yes, sir.
Now, on that taser, there's an officer that says, and I couldn't tell from the video, maybe you could, if someone says, if it doesn't make good contact, we can just keep the foot on the door, she won't come out. If someone said that, based on the door that we've seen, is it really a good idea for Villalobos to stand in that door with his foot on it, with the glass there? Is that safe?
No, sir.
Absolutely not, right? Another minute later, Robert Ramos says, again, the guy is bedridden. So once again, all of our clients know at this point we have a bedridden person there at the scene, right?
Yes, sir.
Regardless of the point that was made yesterday or the day before about him a while later wobbling to the bathroom, he's effectively bedridden as far as any of you guys know, right?
Yes, sir.
There's a fire that happens, he's not making it out, is he?
No, sir.
Probably not. And you know that the law on exigency says an exigency may exist when aiding people whom law enforcement officers reasonably believe require assistance. That would include the bedridden old man in that apartment, right?
Yes, sir.
Okay. Narrowing it down here for you. I'll see Rojas. At 155, we heard a lot about Sergeant Ed Rivera's less than lethal. I think the state called it non-lethal. A beanbag round from a shotgun is not non-lethal, right?
Yes, sir.
We call it less than lethal.
Yes, sir.
And why is that?
Depending where it hits you, I mean, it could be lethal.
It could kill someone, right?
Yes, sir.
In fact, those rounds, those beanbags, you need to be at least 21 feet away from someone, or else you really could kill them if you hit them in the head, right?
Yes, sir.
And so really, despite the best efforts to get these other resources in play here, that shotgun really was not going to be an effective tool given the circumstances, right?
I'm not sure. Yeah,
Probably not, right?
yeah.
Just based on the distance alone, right? We've got a TV, we've got this glass door. It would take a marksman with plenty of calm and time to really hit her. We've got someone running around with a hammer through the apartment, right?
Yes, sir.
Not a good idea to use that beanbag. Because again, when we use less than lethal, we got to be able to get hands-on as fast as possible, right?
Yes, sir.
And that's an officer safety issue as much as it isn't a safety of the suspect and other occupants issue, right?
Yes, sir.
Okay. Now, if we could get through the front door, maybe the beanbag round could be effective as a deterrent, or a ballistic shield could be effective, right?
Yes, sir.
But we know we can't because of that chair, right?
Yes, sir.
And so we have this small patio, just to kind of ask it one more time, if we had officers with guns and tasers and a ballistic shield and a shotgun crammed on that patio with a door that swings out, I think we used the term bad tactics earlier, that would be atrocious tactics, right?
Yes, sir.
Someone's getting whacked with that hammer, at least one person, right?
Possibly.
If she comes running at them and wants to do damage, right?
Yes, sir.
So about 5 minutes before 2 a.m., we're about 7 minutes out from when everything goes down. You'd agree with me that Sergeant Flores' demeanor at the time was calm, right?
Yes, sir.
Collected,
Yes, sir.
thoughtful.
Yes, sir.
He was creating plans and contingencies, right?
Yes, sir.
He didn't have a firearm drawn, right?
No, sir.
No aspeton,
No, sir.
no taser.
No, sir.
No indication that he wanted to do any harm to Melissa Perez that night, right?
No, sir.
In fact, he was being pretty deliberate and tactical, trying to preserve everyone's right to go home that night, right?
Yes, sir.
And that includes Melissa Perez, after jail, getting to go home, right?
Yes, sir.
Elzer Alejandro was calm,
Yes, sir.
composed,
Yes, sir.
friendly even, right?
Yes, sir.
Do you know Alejandro's nickname?
No, sir.
Doug? Ever heard him called Doug?
No, no.
He's kind of like the funny guy. Everybody really likes Alejandro. He lightens the mood, right? And you would agree with me, he was doing that with Melissa Perez that night, right?
Yes, sir.
We can see that on the video. He's attentive, right?
Yes, sir.
No firearm drawn,
No, sir.
no aspeton,
No, sir.
no taser,
No, sir.
no desire on his part to do harm to Melissa Perez that night.
No, sir.
But he also has a right to go home that night, doesn't he?
Yes, sir.
And then Nathan Villalobos, he's calm,
Yes, sir.
composed,
Yes, sir.
attentive.
Yes, sir.
To be fair, he can be imposing. He's a Marine, big guy, but he's being very gentle with Melissa, isn't he?
Yes, sir.
And he just got assaulted by her with that hammer, right? With the swing,
Oh, yes, sir.
where she missed him. And another officer, maybe Vince Gomez, might say, dude, it was this close. I'm with my hands here, it's less than a foot, right?
Yes, sir.
Despite that, Officer Villalobos is still being quite friendly and respectful to Ms. Perez, isn't he?
Yes, sir.
No firearm drawn, no aspeton, no taser, right?
No, sir.
No indication that he wants to do any harm to Melissa Perez that night, right?
No, sir.
And just like you, he had a right to go home that night.
Yes, sir.
So, I want to shift gears here, change it up a little bit. Yesterday, you and Mr. LaHood talked about the 5 C's. Remember that conversation?
Yes, sir.
Okay. Let's chat about that. This will be. Let's do this one. I'm going to show you Defense Exhibit 42. Just tell me if this looks accurate as far as some of the training they give at the Academy for tactical response or disengagement, kind of the factors you look at when dealing with someone in a situation like this. Does that look right to you?
Yes, sir.
Okay. So as a demonstrative, let's look at 42 here. Thank you. I'm going to stand on this side this time so the whole jury can actually see it. Okay. So, tactical response or disengagement. We are dealing with someone like Melissa Perez, who has locked herself in an apartment. Officer,
Just object a moment. Can I ask what the source of this information he's shown to the jury?
I asked him whether it was from the training that officers received at the academy, and he affirmed that it was.
Is this from the general manual?
I'm not sure if it's in general manual.
From your training at the academy as a police officer?
Yes, sir.
Do you recognize it?
Has to
It's not necessarily a chart, it's just the way it's actually written out. So,
You don't recognize this chart in a sense as being used?
no, sir.
Okay, I would object.
Right, defense, you can inquire further.
Thank you. Now, you don't have this chart in the actual training materials, right?
No, sir.
But you'd agree with me that for demonstrative purposes, this accurately reflects some of the contents of the training that you undergo, right?
Yes, sir.
Okay. This time,
Chris, just watch your back on this gentleman right
I'm so sorry. You can't see through me. Okay. All right. Let's do sideways here. Okay. You'd agree that that's a fair and accurate reflection of some of the contents of the training. It's obviously not all of it. You don't have this exact chart, right?
Yes, sir.
But you'd agree this is a helpful way to summarize some of the information you're trained on, right?
Yes, sir.
Your Honor, with your permission, I'd like to use this as a demonstrative.
Yeah, I'm okay with that.
All right. Okay. So with those qualifiers, let's go through it. Question is, that night, Do we leave or do we respond, right?
Yes, sir.
Okay, so if we're dealing with Melissa Perez that night, would you say she was suicidal or not suicidal?
I guess not suicidal.
Not suicidal. Setting aside, of course, the question of whether she was doing a suicide by cop, right?
Yes, sir.
Different issue. Is what she's done that night criminal or non-criminal?
Criminal.
Definitely, right? We've gone through that. Is she alone or not alone that night?
Not alone.
Not alone. And is she just possibly armed or is she armed?
Armed.
She's armed, right? The hammer. So, all our check marks on the right side here. What do we do? Leave or respond?
I guess it would be up to the supervisor at that point.
Sure, but let's say it's you. I'm asking you as an officer. This is what you've got. What are you going to do? Leave or respond?
Like I said, we'll talk to our supervisor
I hear you.
and see what he would say.
I hear you. And I respect that SAPD has a robust supervision environment. It's a big agency. It's gone through a lot. And I'm not asking you to second guess what a supervisor did, but if all our check marks are here on the right side, would you agree with me that a reasonable decision is to respond to the person?
Like I said, we would have to talk to the supervisor.
I get it.
So,
Nonetheless, let's say this then. If the supervisor did tell you, okay, let's respond, would you agree that the supervisor's decision is a reasonable one?
yes, sir.
Okay, all right. I'll take it. So yesterday, you did a pretty good job with Mr. LaHood of rattling off the 5 C's. And that's part of again, training that you get at the academy, right?
Yes, sir.
And along with the 5 C's, you learn about things like creating a react team and kind of different procedures that are good to implement in a scene like this, right?
Yes, sir.
And so looking here at Defenses 43, of course this is not a document that's in your training materials, right?
No, sir.
But do the contents fairly and accurately depict concepts from your training that would be helpful for the jury to understand?
Yes, sir.
Okay. So at this time, Your Honor, I'd like to use Defense 43 as a demonstrative here. Okay. All right. So, and just for demonstrative purposes, Officer Salinas, let's talk about these 5 C's.
No.
So sorry. Just living with this case. Officer Rojas. The 5 C's here. Contain, the term kind of speaks for itself, right?
Yes, sir.
If we're talking about Sergeant Flores and what he's done at the scene there, would you agree with me that Sergeant Flores has successfully ensured that Melissa Perez is contained?
Yes, sir.
Where's she contained?
The apartment.
In the apartment. Given all the officers that are there with Sergeant Flores, with him being in charge, is what everyone said, right? Would you agree that as much as she can be, she's under control in that apartment?
Yes, sir.
We've got eyeballs on her everywhere, right?
Yes, sir.
Would you agree with me that officers, Sergeant Flores himself and others, including Officer Villalobos and Alejandro, are communicating with Melissa Perez?
Yes, sir.
Okay. Call, it's a little short, it's call on specialized resources, right?
Yes, sir.
This could be a couple different things, right?
Yes, sir.
I think you mentioned with Mr. LaHood, it could be SWAT, right?
Yes, sir.
That's a specialized resource. Would it surprise you that a call like this SWAT wouldn't come out for anyways?
Yeah, it all depends.
Those guys can be hard to come to be brought out, right?
Yes, sir.
They're the big dogs. They come out for the really big stuff. As serious as this is, probably not something SWAT's coming out for, right?
Yeah, I'm not sure. Probably not.
Probably not, right? We've talked about mental health unit. I think you testified that at the time it wasn't as big, right?
Yes, sir.
In fact, after 11 o'clock, there was no one to call for mental health, right?
No, sir.
But now there is.
Yes, sir.
After this incident, they've expanded the hours.
Yes, sir.
Okay. So that wasn't available. But a specialized resource isn't necessarily just a team. It can be things like a ballistic shield, right? That's specialized.
Yes, sir.
You agree? Shotgun with beanbags, that's a specialized resource, right?
Yes, sir.
Got to work with what you have. So you'd agree with me that Sergeant Flores did call on some specialized resources, right?
Yes, sir.
Okay. And would you agree with me, and when you watch the video, it's obvious that Sergeant Flores is coordinating a plan here, right?
Yes, sir.
To be fair, we're dealing with a dynamic situation, right?
Yes, sir.
The dynamism is Melissa Perez walking through that apartment, right?
Yes, sir.
You know, just for the record, walking through the well, we've got her walking from room to room with this hammer, yelling at officers, telling everyone, I'm not going back to jail, right?
Yes, sir.
Yeah. Okay, so those are our 5 C's. 1/3 of the way through. React team. There's this concept, right, where someone like Sergeant Flores is going to try and arrange roles for everybody to take on in this situation, right?
Yes, sir.
And as the sergeant who's in charge of this scene, that's Sergeant Flores' responsibility, right?
Yes, sir.
We've got someone that's a communicator. We've got more than one of those, right?
Yes, sir.
We've got people talking to her. We've got, I know it's uncomfortable in that chair. If you need to turn the chair, that's okay too. If a shield could be useful, he calls on somebody to get their shield, right?
Yes, sir.
There's discussion of hands-on taking place, right?
Yes, sir.
Whether we can do that or not. There's discussion of using less lethal cover, right?
Yes, sir.
And you've talked about that. We've seen people that pulled their tasers. We've got the beanbag round. That's less lethal cover for officers, right?
Yes, sir.
And then we've got lethal cover, which is, of course, the firearm, right?
Yes, sir.
Okay, so would you agree with me that Sergeant Flores was doing everything he could to implement some kind of react team that night?
Yes, sir.
Okay. And then, of course, the last item on this chart, on defense 43, we've got containment team or teams. Did we have officers that night ensuring that she was contained to that apartment?
Yes, sir.
Every window, there's no way she's getting out, right?
Yes, sir.
Okay, so you'd agree with me, we have a containment team in place?
Yes, sir.
Okay, so Sergeant Flores, while some might say we have a suboptimal result, a tragic result, maybe it wasn't the perfect tactics, he did everything his training taught him to do, didn't he?
Yes, sir.
Okay. Just checking to make sure there's nothing I've forgotten, Officer Rojas. Appreciate your patience. One last issue I want to hit on. Officer Chernak was there at the scene as well, right?
Yes, sir.
And do you remember Officer Chernak having maybe a different idea about how to go about this?
Yes, sir.
He wanted to go in the back window, right?
I believe so.
One of the rear windows to a bedroom.
Yes.
Do you remember that there was a bunk bed in the way of that window?
Yes.
And you'd have to really be able to climb up into that window and get in there fast to get in that room, right?
Yes, sir.
But Chernak didn't say anything about, well, Flores' plan is a horrible plan, as people are talking about, right?
No, sir.
Not at all, right?
No,
Because
sir.
reasonable minds may differ, that doesn't mean that anybody's acting unreasonably, right?
Yes, sir.
And in fact, if we watch the video, we can actually see that Officer Chernak had a really hard time getting in that window, didn't he?
Yes, sir.
And then I'm not casting aspersions, I would too, it was a tall sill. What's the risk if you are having a hard time getting in a window of an apartment where someone's running around with the hammer? What can happen to you?
You can get hit.
Officer Rojas, I really appreciate your time, and your answering my questions, and I'll pass the witness at this point.
May I proceed, Joel?
Yes.
Officer Rojas, I'm going to show you what's been marked as State's Exhibit number 11. Do you recognize this? Take a look at it.
Yes, sir.
And tell us what that is.
It's General Manual Policy Procedure 502, warrantless arrest, search, and seizures.
Is this what you've been trained at in your academy on what the requirements are and your duties and your protocols for conducting a warrantless arrest?
Yes, sir.
Okay. State would offer what's been marked as State's Exhibit number 11.
If I could just briefly take them on board, Dyer.
Okay.
Very briefly, Officer Rojas, State's Exhibit 11 here. This manual, violation of it isn't necessarily a violation of the law, right?
No, sir.
Okay. No objection.
All right, submitted.
Thank you.
And the state would like to take judicial notice of Texas Code of Criminal Procedure 1405.
All right, I'll take judicial notice of that.
With respect to the training from the general manual here.
Just one moment.
Oh. I'll remember that next time.
It's okay.
Is there a provision in here where an officer is directed about making a delay in making an arrest?
No, sir.
Well, let me refer to you right here. What does it say about an officer's ability to delay making an arrest?
The delay in making an arrest, an officer may, in order to avoid the use of force, delay making an arrest until a more appropriate time, if by so doing he does not jeopardize the eventual arrest.
Okay.
And then, you want me to read all of it?
Sure, if you want to.
Oh.
Is there another provision? Yeah, there's another provision there.
An officer obtains a warrant if a misdemeanor is committed in his presence or view, and he does not arrest at the time of the offense is committed.
So it's directing you, you can delay making arrest, right?
Yes, sir.
And it says, but if you're going to do that on a misdemeanor, then you need to follow that up with a warrant.
Yes, sir.
That's right. Okay. Under section here where it says B, rights of officers, what does it say there?
When an arrest may be lawfully made without a warrant, an officer making the arrest is justified in adopting all the measures which he might adopt in cases of an arrest under a warrant, except the officer making the arrest without a warrant may not enter the residence or to make the arrest unless a person who resides in the residence consents to the entry, and B, exigent circumstances required the officer making the arrest enter the residence without the consent of a resident or without a warrant.
Okay, and that provision is a directive to you about what your legal authority is to enter a home,
Yes, sir.
right, for the purpose of making an arrest,
Yes, sir.
right? And it tells you that you need what?
A warrant.
A warrant.
Or it says,
Correct.
or exigent circumstances, or a warrant.
Warrant, exigent circumstances, what's the third one?
It says permission to for residence.
Consent, right?
Yes, sir.
Permission, right? Three things to enter a residence. Consent, a warrant, or exigent circumstances. Is that what it says?
Yes, sir.
Okay. Did you know that?
Yes, sir.
Right? And when we talk about exigent circumstances, what do you understand as an officer what exigent circumstances are?
If somebody's life is in danger of serious bodily injury or death, if to avoid escape, and also to avoid any destruction of evidence.
Okay. Now, did you have any reason, the time that you were having your communication with Melissa Perez, did you have any reason that she was in the course of destroying evidence?
No, sir.
Did you have any reason to believe that she was going to be able to get away?
No, sir.
Did you have any reason to believe that she was a threat to someone else in that house?
No, sir.
Okay. Who was she? Who did she become a threat to?
The officers.
When?
When we every time an officer got near her home, the window.
Every time, and only when. Am I right?
Yes, sir.
Only when an officer tried to enter her window, right?
Yes, sir.
Now you did you grow up in San Antonio in Texas?
Yes, sir.
Okay. And are you familiar with a person's rights to protect their property?
Yes, sir.
Okay. And if you as a homeowner, right,
Yes, sir.
had a person trespass on your land,
Yes, sir.
right?
Objection,
Oh.
Your Honor, this is improper. He's going where the court has already ruled this is improper.
I've got no such ruling as that. May he answer the questions in the same way he answered the questions
Judge,
for
this is
them?
improper.
But Judge, you already ruled that they can't make this argument because it's not the law. I understand they want it to be the law, but it's not. You made that ruling outside their presence, because now you brought it up, we can talk in front of their presence. This is not the law. It's ridiculous.
All right.
You just took judicial notice, Your Honor, of the law.
But it doesn't apply to officers. We talked about this outside their
It's
presence.
called rights of officers.
All right, so I'm gonna allow these questions, and if he gets any closer, the defense are welcome to
Get ready for the cross.
Now, as a property owner, right, in Texas, do you also have rights to use force to protect your property?
Yes, sir.
In what instances?
Whatever force you feel necessary.
I'm sorry?
Whatever force you feel necessary.
If you had already described, I think that you judicial notice what a criminal trespass was, right? If somebody comes onto your property without your consent,
Yes, sir.
right, and you've given them notice to depart,
Yes, sir.
and they do not,
Yes, sir.
right? Is that criminal trespass?
Yes, sir.
Right. Absent some other lawful authority, that's a criminal trespass, right?
Yes, sir.
Now, I want to talk about, in the same way that you're talking about how you would feel, I'm talking about from Melissa Perez's position, from her perspective.
Objection, Your Honor. This court has already ruled that we cannot ask this question based upon our motion in limine and your ruling on the motion in limine in the case of Mays before the court of appeal explicitly rejected this ability to resist arrest or use deadly force when police officers are trying to make an arrest.
That has nothing to do with entering property, Your Honor. It has nothing to do with entering property.
All right, I'll overrule the objection.
And it's not relevant because in order to avail yourself of the defense, you have to have confession and avoidance. And I think that Mr. Norton earlier said that 902 talks about prosecution of a defendant. You can use justification, and we're not dealing with a defendant's perspective here. I think this is improper, and it's misleading the jury and calls for speculation, and there's no evidence to show what the state of mind of the so-called person that the state is proffering.
There's abundant evidence of the complaining witness's state of mind and multiple questions asked from each of these lawyers about their state of mind, Your Honor, and it's all on
And-
videotape.
Your Honor, the Mays case explicitly said that a person who is mentally ill cannot avail themselves of justification defense because of the requirement of reasonableness. The Mays case is explicit in that it's not permitted because of that very fact. It dealt with that very issue where the person on trial was in a mental state of decompensation, and the court said, by that very fact, you couldn't even present
Your Honor,
the
that case,
defense. Wait a minute, I'm not finished. You can't even present the defense because by the very nature of the evidence, the person could not be reasonable under the definition of reasonable person in the penal code.
Your Honor, that case is inapplicable in this case. It involved a response by police to a situation where a person was committing family violence at the time that the officer made entry. Not this case.
All right, I'll overrule.
Now, when you had your contact with Ms. Perez, right, you had testified earlier that you did not arrest her.
Yes, sir.
Did she ask you if she was under arrest?
Yes, sir.
And you told her what?
She wasn't.
Is it reasonable to believe that she thought she was free to leave?
Yes, sir.
Okay, and then when she trotted away to her apartment, Officer Ramos engaged in chase of her, is that right?
Yes, sir.
What facts did Officer Ramos have that she did anything?
Just whatever was on the key card.
Key card didn't even identify her, right?
No, just give a description of her.
So he didn't have the benefit of what you knew when he chased after her. Did he?
Yes, sir.
Did he?
Oh, no, he didn't.
And so when she got to her apartment and Officer Ramos is trying to kick in her door, you are not.
No, sir.
Why not?
Because we didn't have a warrant.
Because we didn't have more. You expressed that multiple times during your time out there, didn't you?
Yes, sir.
Did you say something to the effect of, they'll never let us break down that door?
Yes, sir.
And why did you say that?
Like I said, it's one of those things. She was already in her house, and she was in there by herself. Oh, not by herself, but she was in her house.
So when the defense is asking you, this question about there's no safe place for a person to go, is that true?
Well, I mean, if they don't, I guess it's one of those trick questions. So.
If, for example, that a suspect had been driving while intoxicated, running through intersections with red lights, and got out of the car and you were chasing them, and they ran into their garage, you'd be allowed to chase them into their garage, right? Immediately.
It depends, yes. I mean, it all depends.
Depends. It still depends.
Yeah, I mean, yeah, it's one of those things.
But in a situation where the person is in their house, they weren't under arrest. You had told her she wasn't under arrest.
Oh, yes.
Right?
Yes, sir.
Did you feel you had any legal authority to go into her house after her?
No, sir.
Okay. And did you ever go into her house after her?
No, sir.
And did you ever kick on the door to get into her house?
No, sir.
Did you ever reach into her window to get into her house?
No, sir.
And during this time that you were waiting, were you trying to persuade her to come out of her house?
Yes, sir.
Was that the tactic?
Yes, sir.
Right. Had you in your mind ceased any idea of all about going into her house to get her?
Yes, sir.
Had Officer Ramos ceased any idea about going into her house to get her?
That's a speculation.
I'll sustain.
From his conduct that you observed during that time that she wasn't able to get in after the first couple of kicks?
No, sir. After the kicks, you mean?
Yeah, after the kicks.
No, sir.
And when Mr. Cifuentes was showing that extended video of you and Ramos talking about the dispatcher and the night's activities and that kind of thing, were you continuously trying to get into her apartment at that time?
No, sir.
Had you disbanded that idea?
Yes, sir.
And when you were waiting for Officer Salinas to arrive, and when he showed up, and you had that discussion with him, did you resume making any efforts to go back into her apartment?
No, sir.
And at that period of time, Mr. Newman showed you a chart there, the criminal mischief chart, right? Did you have all the elements at that point?
Not the actual price.
You didn't know the value.
The value, yes.
Right?
Yes.
Was this is a property crime?
Yes, sir.
Right? How often in your time and in your training do you go after somebody into their home for a property crime?
Not very often.
And does it require, for you to do so, does it require the authority of someone besides you?
Yes.
Who does it require the authority of?
We have to get a warrant.
You have to get a warrant.
Yes, sir.
And is it you that goes and decides whether to seek a warrant, or is it someone else?
It's the follow-up unit.
Follow-up unit.
Yes, sir. Whoever like property crimes would be the follow-up unit for a property crime. Or, I mean, the criminal mischief.
In the nighttime. Right?
Oh, night CID.
In the nighttime, night CID is who at that time would have to be contacted.
Yes, sir.
Right? And was night CID contacted?
As far as when Salinas I guess when Salinas called.
Okay, not by you, right?
No, sir.
Because by the time that decision was sought, were you still in charge?
Yes, sir.
Well, by the time the decision to call night CID,
Oh, no, sir.
who was in charge of the scene and the call at that point?
Salinas had taken over the scene.
Okay. Mr. Fuentes had asked you multiple times about, but for you not arresting her, the violent confrontation between Melissa and these officers would not have happened, right?
Yes, sir.
But for Sergeant Flores authorizing the entry into that home, this violent confrontation would have never happened. Would you agree?
An objection calls for speculation as to causation.
Sustained.
Well, what changed the course of activities for that night between you ending the call, Officer Salinas ending the call, Officer Flores ending the call, gonna write it up and go home? What changed that course?
I'm gonna object to lack of foundation. This officer does not have personal knowledge of that.
All right, you can rephrase the question specifically to address.
Do you know? Do you know what changed the course?
No.
What changed it from a closed call to an open call?
Objection asked and answered. He said he doesn't know.
Do you know?
Just the fact that the maintenance man got there.
I'm sorry?
The maintenance man?
The maintenance
yeah,
man
the fact that
showed
he
up.
got there. Yes, sir.
And so was the investigation reopened?
Yes, sir.
And you were part of that, listening to that?
Yes, sir.
And after the information from the maintenance man, did you have authority, you personally, as a patrolman, have authority to authorize the entry into Ms. Perez's home?
No, sir.
Did Jonathan Salinas, as a patrolman, have the authority to authorize the entry into Ms. Perez's home?
No, sir.
Okay. Did he seek that authority elsewhere?
Yes, sir.
And did he tell you, it's on the video, did he tell you who he got the authority from?
He said he called night ID, and then he called Sergeant
Sergeant who?
Flores.
This gentleman, Sergeant Flores?
Yes, sir.
And was it what he represented to you on the video that Sergeant Flores authorized them, you and Salinas and Ramos, to enter back into her apartment?
I'm gonna object. That's a mischaracterization of the evidence. Salinas does not say entry. He said we can go get her.
Go get her. Do you agree with that?
Yes, sir.
And go get her meant what?
Objection is speculation as to what Sergeant Flores may have allegedly said to Officer Salinas and what he may have meant by those words.
You can rephrase your question.
What did you understand those words to mean?
Just go in there and get her. I mean.
Go get her. Now, Sergeant Flores, was he your supervisor as well?
Yes, sir.
And do you rely on your supervisors to have more knowledge, more training than you do?
Yes, sir.
And do you, in moments of uncertainty, rely on the training and position of your sergeant?
Yes, sir.
Did you do that here?
Yes, sir.
Now let's go back to the damage they showed you on the door to the sprinkler room of the fire department sprinkler room on the adjoining, the different apartment building. Do you remember that?
Yes, sir.
Okay. Do you know when and how those marks or scrapes along the lock got put there?
No, sir.
Do you know if Melissa Perez did that?
No, sir.
How old is that apartment complex? Do you have any idea?
I'm not sure. It's pretty old. It's over 10 years, I'm sure.
Right. Do you know whether or not the door could have been unlocked when she entered?
I'm not sure.
And with regard to the evidence that you had, that she was actually the actor that did it, had you interviewed any witnesses that saw her do it?
No, sir.
So the only source of information you had that she cut those wires was what?
From the firefighter, I believe the lieutenant.
From the what?
Did they
The
say-
lieutenant, the
Okay.
firefighter.
Right. Did they see her do it?
No, sir.
So the only evidence that she did it was from where?
From the lieutenant, saying that he had a recording.
That she said she did it,
Yes, sir.
right? That she said she did it. That was really the only evidence you had that she did it,
Yes, sir.
right? Does everything she said, did that end up bearing out being true?
Yes, sir.
Well, what about being Elvis Presley's daughter?
No, not that.
How about,
No,
how
sir.
about the FBI is watching me?
No, sir.
How about, I got impregnated and held as a hostage, last year and had a baby? How about that?
No, sir.
Don't know, right?
Yeah, I don't know.
But was there concern about whether she was a good historian? A
Yes.
good credible
Yes.
person?
No, sir.
Didn't know?
Yeah.
Didn't know anything about it? Is that fair to say or not?
Yes, sir.
And so when you urged her over to your vehicle, right?
Yes,
You
sir.
started to try to get some knowledge about this woman. You decided, as your policies allow you to do, to hold off making an arrest.
Yes, sir.
You already knew her name, didn't you?
Yes, sir.
You knew where she lived.
Yes, sir.
Did she seem to be someone that would disappear forever and ever if you didn't get her arrested right there and then?
Objection, speculation.
What was your thought?
Still speculation.
It's
It's the
a
foundation.
Yeah, I'll sustain, I'll let you rephrase.
Okay. Did you, in making your determination, think this is a person I'll be able to find again?
Yes, sir.
You knew where she lived. You know where you knew her name.
Yes, sir.
Right. You knew her date of birth. Right?
Yes, sir.
And she was cooperative.
Yes, sir.
She wasn't threatening to anyone that you saw.
No, sir.
Now, with respect to this emergency detention and your authority to do so, just because you encounter someone that you suspect has mental illness, perhaps experiencing delusion, is that alone a criteria for you to lock them up and take them involuntarily to the hospital?
No, sir. It's just some of the criteria.
Some of it,
Yes, sir.
you need more, right?
Yes, sir.
Okay. Now, with respect to the other officers that were there, how many would you say that were there during the critical moments of this early morning?
I'm not sure, over 10, I'm sure.
Over 10, right?
Yes.
And with respect to the only people that were charged in Melissa's death, what of the other officers fired their weapon at Melissa Perez?
Excuse me?
How many officers fired their weapons at Melissa Perez?
No other ones.
You don't know?
No other ones that I know. I mean.
So, when all these particular offenses are enumerated, the assaults, the evading with a deadly weapon, the resisting with a deadly weapon, all those kind of things, does Melissa Perez, as a citizen, have the same justifications available to her that a police officer would have to them in using force or deadly force?
Yes, sir.
That's not the law. That's not the law. That's not the law, Judge.
I didn't say it was. I'm asking him the
Well,
question.
then it's misleading question because he's saying something that's not the law. So disregard. Then should we tell him that, Judge? Instruction and disregard.
I'll sustain, and members of the jury, I'm going to instruct you to disregard the last question and answer it.
Does Melissa Perez have rights as a citizen to protect her property?
Yes, sir.
Okay. And if Melissa Perez was inside her home,
Yes, sir.
right?
Yes, sir.
Is a home one of the parts of property that she has rights to be able to defend?
Yes, sir.
And if someone is unlawfully interfering with her property or trying to enter her property, does she have rights under our laws to protect her property?
I object, it's irrelevant.
I'll sustain, I'll let you rephrase.
Okay, well, then back up first. Did you see on the video, Officer Salinas, tear out the window screen of Miss Perez's apartment?
Yes, sir.
I mean, that damaged it, right?
Yes, sir.
And if a person damages someone's property, right, particularly a window screen as an entryway into their apartment, is that absent a justification, absent a lawful use of force, a criminal mischief?
Okay, Judge, same objection. He's rephrased the question, but it's applying to the same individuals. These are police officers. Mr. Lumen knows this is not proper. We've talked about this over and over again, so now I can only assume this is deliberate. He's deliberately doing this, and it shocks me about David. Because we talked about this, you said not to go into this.
I
This
object to
let me
personal
finish.
attacks.
Well,
No,
it's not,
I
it's
object to
reality.
personal attacks.
Deal with
It's not-
reality.
it's not
Sorry you
true.
don't like it.
Your Honor, he
The
doesn't
fact
like the
is-
law.
All right,
the
let
fact-
me interrupt.
I don't like the law?
You don't?
Please.
Not when it affects.
All right,
the
let me
law.
interrupt, let me interrupt.
You can lie all you want,
Let me
but
interrupt.
that's not it.
No personal attacks. Just direct all objections and responses to the court. I'll sustain.
If a person tears the screen, if a person would go onto your property, right, and tear the window screen of your property.
Judge, same objection, Judge. This is the same objection. I don't understand what he doesn't understand.
I'll sustain.
And also.
Well, I don't understand what the
I should
objection
point-
is, Your Honor.
I should point out that it's in this statement of facts, and assuming facts, not in evidence, no screen was formed here, and the person that knocked the screen out was Melissa Perez when she struck it with a hammer.
All right, I'll sustain.
The video will reflect what the video reflects, right, Your Honor?
Yes.
Mr. LaHood asked you during his cross-examination whether or not you were trained on what a barricaded subject was.
Yes, sir.
As part of your police training?
Yes, sir.
Was it an in-service?
They do it. They do it in service, and they do it throughout the different times.
Okay, and what is a barricaded subject?
Barricade subjects is somebody who's inside their home, and not a danger to anybody. And
So
so.
was, I'm sorry, I didn't mean to interrupt.
Yeah, just I mean it's when we deal with it. They could be suffering from like a mental episode, or even if they broke the law or something, they went to a home. At that point, they're in there and they're not coming out.
And you as a patrolman, do you have any authority to go into a home of a person who fits the definition of a barricaded subject?
Objection is irrelevant because Melissa Perez was not a barricaded subject by the answer that he gave. Someone who is not engaged in criminal conduct and not a danger to themselves. If he and alone, and
Your Honor, I
if
object
he
to
was
Ben
if he-
testifying.
if he
This
was
is a
gonna
question
ED
for the
if he's gonna ED her, she
can't do this.
All right, let me overrule. But I am going to instruct the state to rephrase that question.
I will. Do you believe that Melissa Perez was a barricaded subject?
At that point, she was inside her home, so yeah, I mean she was in there. Yes.
You did, right?
Yes.
And did you feel that you had any authority to take any action to go into a person considered to be a barricaded subject?
objection asked and answered.
Overrule.
No.
And so given your training about barricaded subjects, did you have to seek the guidance of your supervisor to decide whether or not to go in?
Yes, sir.
Okay, and was that done here?
As far as whenever Salinas made the phone call, I'm not sure exactly what said.
Mr. Newman had mentioned that there were other sergeants on the scene,
Yes, sir.
right? But even though there were other sergeant at the scene, who was in control, who was in command and control of the scene?
Sergeant Flores.
Sergeant Flores was, right? Because why?
Yeah, I think he was, that day he was assigned to that, not the district, but the actual section.
In your experience as a San Antonio police officer, is entering into a residence without a warrant, absent exigent circumstances, to take a suspect into custody consistent with San Antonio Police Department policy?
Yes, sir.
Is it consistent?
Oh, no, I thought you were reading.
Can you rephrase it? Real
Yeah,
quick?
yes, can you rephrase it?
Say it again? Yeah, I'll read it. In your experience as a San Antonio police officer, is entering into a residence without a warrant, absent exigent circumstances, to take a subject into custody consistent with San Antonio Police Department policy?
No.
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 Right?
Yes.
Now, was there any discussion that you were aware of there about even calling the SWAT, calling SWAT?
I'm not sure.
Were you involved in that?
No, sir.
You didn't.
No, sir.
You didn't hear anyone discussing whether SWAT would be called?
I didn't hear anybody.
Did SWAT ever show up?
No, sir.
When Officer Salinas was struck by the candle, on whose property was he standing?
Just on the patio of
Whose patio?
Melissa Perez's apartment.
Was that community property or was that her property?
Her property.
Her property, right?
Yes, sir.
With respect to the shield, you saw the shield yesterday. That demonstration was done with you, right?
Yes, sir.
Would that shield have provided a degree of safety in the hands of an officer who's approaching the door with the glass thing in it against the door, right? Would that have protected that officer from any danger of serious bodily injury?
I mean,
What do you think?
it could. I mean, just.
I mean, could that shield cover from the top of the head down to close to the knees?
Yes, sir.
And if someone was armed with that shield, could they have stepped past the barrier? Because there's a wall there too, right? Between the door and the window?
Yes, sir.
It's a barrier,
Yes.
right? Right?
Yes.
Could a hammer be thrown through that wall that separated the door from the window?
To the wall?
Yes, through the wall,
Not the wall.
right? That hammer was no danger to somebody on the other side of that wall, would you agree?
Yes, sir.
And if somebody was holding that shield next to that window, would they have been at risk of serious bodily injury from a person holding a hammer?
I'm gonna object to this continuously leading line of questioning.
Or also staying leading.
Tell me, in your opinion, if a person was standing next to that window with the torn window screen, with that shield, would that shield cover up any of the space that a hammer could be thrown through?
Yeah, possibly.
There's something else covering that window too, isn't there? What was it?
There's a TV.
TV was there, right?
Yes, sir.
Okay. So that shield doesn't just have utility with somebody with a firearm, right? It would have utility against somebody with an impact weapon, wouldn't it?
Yes, sir.
Mr. Cifuentes was asking you about something you admitted to include in your report or your statement. Do you remember that?
No, not sure exactly.
Okay. Pat Roach?
Yes.
Do you recognize this as the statement you gave earlier that morning?
Yes, sir.
He had asked you about whether you had failed to talk about in your statement about seeing Melissa Perez come at Officer Salinas with a hammer right before throwing the candle. Is that what he asked you?
Yes, sir.
Do you remember that?
Yes, sir.
And did you omit that, or did you include that in your statement?
It's in the statement.
It is in there, isn't it?
Yes, sir.
You did include that fact in there.
Yes, sir.
Okay. Thank you.
At any time during the course of this event, other than people trying to come into her apartment, did Melissa Perez show any threats to anyone whatsoever?
No, sir.
When Sergeant Flores approved the return to the apartment and to go get her, that situation, did Sergeant Flores even know anything at all? Was he told anything at all about there being another man in the room?
Speculation, Judge, at that point.
Did you know?
I'll sustain that. You can only answer that if you have personal knowledge of that.
No.
Did you know there was another person in the apartment at that time?
No. Or just from what she had said at
Just
the
what she had said
initially.
prior.
Yes, at the.
Had you seen him?
No, sir.
Never saw him by the time that happened, right?
Yes, sir. We didn't see him.
Yeah, I'm sorry, you did.
Oh, didn't see him.
Were you surprised that Sergeant Flores gave authority to force entry into that apartment?
It's irrelevant, Judge.
Objection. And that's a misstatement of the evidence.
Yeah. I'll ask him what he's surprised about a lot of things too, if you don't object to me. I mean, that's irrelevant.
I'll sustain.
You watched your video, right?
Yes, sir.
How did you react to Officer Salinas telling you we could go in?
I just asked him who had told him that.
And why did you ask it that way?
Usually we don't get approval to go into places.
Okay. Now, with respect to any plan that was initiated or pursued, were you included? Were you invited? Was it one discussed in your presence about how Melissa would be extracted from her apartment?
There's just talk. There's talk about a plan. Some of the guys were talking, and that was it.
Of the officers that were there at the scene, who knew the most about Melissa Perez?
Who knew the most?
Yes.
What do you mean?
Well, who knew the most about, or who had had personal contact with it?
Myself and Salinas.
And
Oh,
Salinas?
I did.
You did?
Yes, sir.
Right. Did Sergeant Flores ever come speak to you about what you knew?
No, sir.
Did Officer Villalobos come speak with you about what you knew?
At one point I was talking and he was in the area.
And he walked away?
Yes, sir.
Do you remember that?
Yes, sir.
Did Officer Alejandro seek any information from you about Melissa Perez?
No, sir.
About the circumstances that had occurred before earlier?
No, sir.
About the fact that you never arrested her?
No, sir.
None of them were interested in what you had, what you knew?
Nobody.
So I had your Honor, I'll pass it.
So, Officer Rojas, did you meet with the government yesterday after you testified?
No, sir.
You didn't talk to anybody from the government at all?
No, sir.
When did you come up with, I never got to that point? You said that about, I counted 23 times, I think.
Who?
I never got to that point. Did you just think that in your own mind?
Yes, sir.
Okay. So I want to talk to you about a lot of things, because he brought up on redirect. He said that Melissa Perez was cooperative. Do you remember him asking you that?
Yes, sir.
Until she wasn't, right?
Yes, sir.
Because at some point she was cooperative according to the government, but then she wasn't cooperative because she committed 5, 6 aggravated assaults against peace officers, right?
Yes, sir.
And in relation to a burglary of a building, we went over that statute. You remember us talking about that?
Yes, sir.
You're well aware of, as they are, that it doesn't need to be locked for someone to be guilty of burglary of a building, right?
Yes, sir.
It doesn't need to be locked, right?
Yes, sir.
So if the door's unlocked, someone can still be charged with burglary of a building. They can still violate that statute, right?
Yes, sir.
And everybody knows that the study's the law, right?
Yes, sir.
Okay. So when it comes to policy, policy is dependent on different police departments. Would you agree with that?
Yes, sir.
But policy is not the penal code.
No, sir.
Because in SAPD, there's a policy not to chase people in cars,
Yes, sir.
right? It's called a no chase policy.
Yes, sir.
But that's not anywhere in the penal code.
No, sir.
Because other police departments do have a chase policy.
Yes, sir.
Matter of fact, Bexar County Sheriff's Office, I believe, has a chase policy.
Yes, sir.
Correct? So, may I stand up, Judge?
Yes.
So you have Bexar County, it's the county that San Antonio's in, right?
Yes, sir.
And then you have San Antonio that's within the Bexar County, right?
Yes, sir.
And they both have different chase policies.
Yes, sir.
Different police departments have different choke policies, right?
Yes, sir.
And that's a less lethal way of detaining somebody, but some departments don't allow you to choke.
Yes, sir.
Other departments allow you to choke.
I'm guessing I'm not
You
sure.
never worked for another
No,
department?
no, I haven't.
If I represent you, then they do, would you believe me?
Yes, sir.
Thank you for that. And but that's a policy decision, that's not the penal code, right?
Yes, sir. It's a policy.
Under the penal code, it would be an analysis of whether that was reasonable or not, but that's just separate policies. You agree with that?
Yes, sir.
And so I believe that Mr. Lunan went up to you and showed you the general manual, specifically the portion that talked about delay in making arrest. Do you remember reading that out loud to the jury?
Yes, sir.
And then he didn't want you to read the next sentence, but thank you for reading the next sentence. What did you read? It kind of messed him up a little bit. It said, this is only relation to misdemeanors, right?
Yes, sir.
You can make a decision to delay an arrest with misdemeanors, but not with felonies.
Yes, sir.
Because a felony is a different ballgame. Would you agree with that statement in general?
Yes, sir.
Matter of fact, we went over chapter 14, that a felony committed in your presence, you have a duty, and your general manual says that, to go apprehend somebody and arrest them and bring them to a court of law before a judge or a jury so they can be held accountable, correct?
Yes, sir.
And so there isn't a discretion when it comes to felonies.
No, sir.
If you're reported to Internal Affairs and gets up to brass that you repeatedly did not arrest people and apprehend them for committing felonies in your presence, or if you had probable cause that there was a felony, you would get days or suspended or fired. Would you agree with that?
Yes, sir.
Because we as a community and SAPD takes felonies very seriously, right?
Yes, sir.
We're going to talk about more of that in a second. So the government also asked you, Mr. Lunan also asked you about when you can enter a residence. God bless you. And when you can enter a residence. Remember hearing that question?
Yes, sir.
And he was asking you that question in relation to police officers, right?
Yes, sir.
What point do you think he was making with that?
I'm not sure, sir.
I'm not either. Okay, but when it comes to legal authority to enter, because then he went to legal authority to enter, and he said, he read the statute to you, that you can enter without a warrant, you can enter someone's property with a warrant, exigent circumstance, or with permission, right?
Yes, sir.
Now, if an officer, and I'm not saying that's the situation, we'll get there in a second. If an officer enters a residence without permission, what is the remedy for that?
Excuse me?
If an officer mistakenly, may I stand up, Judge?
Yes.
If an officer, officers make mistakes, right?
Yes, sir.
And they're not trying to do things criminal if they make a mistake, right?
No, sir.
Not every one of them,
No.
right?
Yes, sir.
Okay, because we're gonna talk about Ramos's mistakes and yours in a little while. So if an officer mistakenly enters a property, what's the remedy to that? In our system, what's the remedy to that?
Well, I don't.
Well, how do you remedy that? I guess what I'm saying is a citizen, is any one of these citizens out there, are they allowed to attack that officer?
No, sir.
Are they allowed to punch him,
No, sir.
kick him,
No, sir.
hit him with a hammer,
No, sir.
shoot them,
No, sir.
stab them?
No, sir.
No, what you do is you hopefully get lawyers and you file a motion to suppress, and you get subpoenaed into court, and we go before a judge, and then a judge either kicks out that evidence or not, right?
Yes, sir.
And then somebody reports to IA. What does IA mean? Will you explain to this jury what IA is?
Internal affairs.
What does internal affairs do for your department?
They investigate any wrongdoing, for police officers.
That's right. They investigate any wrongdoing of police officers, and they do an investigation, right?
Yes, sir.
They'll talk to lay witnesses.
Yes, sir.
They'll look at body cam.
Yes, sir.
They'll go get cameras or video from any outside sources, and they'll make a determination if an officer did any, your words, wrongdoing, correct?
Yes, sir.
And then what happens if they find wrongdoing?
It all depends of what they can get suspended, fired, or
Suspended, fired,
Or
or
they-
it could lead to being charged
Yes.
with something if it's real criminal, right? Okay, so when you're talking about entering a structure, you know, we all know that an officer is not charged with criminal trespass every time that they come into court for a motion to suppress, right?
yes, sir.
Because a motion to suppress essentially is telling a judge, this officer was trespassing on my property. We say illegally, but not penal code illegal. They were there improperly. I want you to kick out all the evidence that they found when they came into my property improperly, right?
Yes, sir.
They're not charged with criminal trespass.
Um,
In your 9 years, how many times has this table here, the government, how many times has the government charged an officer for violating someone's constitutional rights, and I'm not saying that happened here, and went onto a property when they shouldn't have? How many times have you heard about an officer charged with criminal trespass?
None.
None in 9 years, right?
Yes, sir.
I've never heard it in 23 years. So then, I sustain your objection. And so when we go further, so now we get into exigency. What does exigency mean?
So agency gives you have to determine if somebody's in danger, or either serious bodily injury, or death, or in order to gain entry to make the arrest, things like that.
Can we just say that the way I remembered it from law school is exigent means emergency?
Yes.
E and E makes it easy to remember. So exigency means emergency. As it could be flushing drugs down the toilet, that's emergency,
Yes.
right? That wasn't the case here,
No.
right, that we knew of. But it also could be that someone's in danger, right?
Yes, sir.
How about if somebody's been assaulted?
They're being assaulted.
What if they have already been assaulted?
They already were assaulted,
Yes, sir.
and they're still in the home,
Yes,
or it could be, depends.
May I push it?
Yes.
So let's say, in our scenario, that Melissa Perez would have gone up to Mr. De Los Santos and hit him, just like that, I mean, just that. that hard. Could the officers gone on to get him? get her?
To get her?
Mhm.
I mean, yeah, if he was in danger.
Why are you stuttering with that answer?
Because if he was in danger,
I just said in my scenario, she did this to him. She did that to him.
was it like right away or when
Who
we were?
cares? At any point. At any point, if she did this, could they gone in and gotten her, arrested her?
Like I said, if it happened when we were there and we heard it happen, yes, we could. That's exigent circumstances.
And I'm not being disrespectful, please be patient with me, because I'm frustrated with these folks behind me. Why are you having a hard time with that question? This is not a hard question.
I'm explaining to you.
Okay.
If it happened while we're there and we heard it and they're actively yelling, "Oh, he hit me! She hit me with the hammer," yes, we could go in there.
So you saw it happen, you can go in.
Yes.
So if you see an incident happening what's the curtilage of a property? What does a curtilage mean?
Means the properties, the area surrounding the property.
It's still part of that property, right?
Yes, sir.
The Fourth Amendment, your constitutional rights apply, so that's part of your property. Your curtilage, your anywhere on your property, your curtilage, that's property.
Yes, sir.
So if an assault happens on the curtilage of the property, it happened on the property.
Yes, sir.
And the person responsible for committing that aggravated assault on the curtilage of the property can be detained.
Yes, sir.
And you agree that a porch is a curtilage of a property.
Yes, sir.
So the fact that Melissa Perez committed multiple assaults on her curtilage of the property, that is an assault that happened on her property, and she could be detained.
Yes, sir.
And that would be an emergency.
Yes, sir.
So based off their questions, I think he talked about she became a threat. Do you remember this question? She became a threat to officers only every time the officers tried to enter the window. Do you remember that line of questioning?
Yes, sir.
And he talked about right to protect property, right?
Yes, sir.
So when you have a right to protect your property, that means if you use force to protect your property, you are what they call justified in using that force.
Yes, sir.
So if out of the one of those 5 times that Melissa Perez would have accomplished her goal on Salinas and Villalobos, do you think that she should have been charged with capital murder if she killed either one of those men?
Yes, sir.
She should have been charged with capital murder, right?
Yes, sir.
So she did have a right. Because if she had a right to defend her property, okay, then that means that she could have used force. And that means that she couldn't be in trouble for using force, right?
Yes, sir.
So if you and I, may I push, Judge?
Yes.
If you and I are at a restaurant, not that you would want to go eat with me, but just in case we did, we're at a restaurant and someone walks in, everybody in this restaurant, give me your money. And then you're in plain clothes, and I'm in plain clothes, and you and I are carrying, right, concealed. And then someone comes in with a gun and they're pointing at everybody, asking for and you and I draw weapons and we shoot. Would we be charged with murder?
No, sir.
Why? Tell the jury why.
Because we're protecting the people in there.
Third person, right?
Yes, sir.
Penal Code 9.33. Use of deadly force to defend a third person. And ourselves, technically,
Yes,
right?
sir.
Okay. So that table right there, they couldn't charge us with murder.
No, sir.
Well, they could, but they shouldn't, right?
Yes.
And so in this scenario here, you're not agreeing with them that she had a right to use force against these officers, are you?
No, sir.
So he asked you again, we went back to the beginning. I think Mr. Luna went back to the beginning about Ramos chasing her. And he asked her that you said she was not arrested or detained. Did you answer his questions that way again?
If she wasn't arrested, detained?
Yes, sir, at the very beginning.
No, she wasn't arrested. She had asked me about if she was arrested, and I told her no.
So now you're a witness,
Mm-hmm.
right?
Yes, sir.
To an attempted burglary of a habitation. Why do you think they didn't charge him for that, Ramos? Since officers can be charged for these things, why didn't they charge him with attempted burglary of habitation?
I'm not sure, sir.
No, he brought it back up and redirect, Judge.
Overruled.
So why do you think this table didn't charge him with attempted burglary of a habitation?
No, I'm not sure.
I'm not either. But what I'm saying is apparently broke the law, right? Officer Ramos broke the law, according to them,
Yes, sir.
and you're a witness.
Yes, sir.
But under the law of parties, you might need a lawyer because you could be just as guilty because you furthered it. You let him kick the door. Did you know that?
Yes, sir.
Well, so you let him break the law. So under the law of parties, as they talked about before, you're just as guilty as Officer Ramos.
Yeah, I guess so.
You
Yeah.
are, right?
Yeah.
Don't say yes if you're going to incriminate yourself, but you didn't do that. I'm saying you didn't break the law, neither did Officer Ramos, did you?
No, sir.
No officer that night was breaking the law when they were trying to detain her after committing multiple felonies. Would you agree with that point?
Yes, sir.
Now, we talked about property crimes versus assault. Now, we went over this already, but he brought it up again in redirect. There's a continuum. We talk about a continuum of force in self-defense. Remember we talked about that when I crossed you?
Yes.
And things can change quickly, right?
Yes, sir.
Did you remember Miguel Moreno?
Yes, sir.
Passed away?
Yes, sir.
Did you ever see that video?
No, I didn't, sir.
But you heard about it, right?
Yes, sir.
You heard about the fact that it went from 0 to 100. May I stand up, Judge?
Yes.
Self-defense situations and just situations can go from 0 to 100, right?
Yes, sir.
Someone could draw a weapon, someone can attack you with a hammer, or stab you with a knife. And so there's this continuum that happens very, very quickly, right?
Yes, sir.
And so there's, as we talked about, there's kind of these sections of this encounter. There's you and Melissa Flores at the beginning, correct?
Yes, sir.
There's Officer Ramos coming into the scene.
Yes, sir.
There's this attempt to get in hot pursuit, correct?
Yes, sir.
There's the entry of Officer Salinas that comes onto the scene.
Yes, sir.
And it was you very happily giving him over the lead, it seems like, right?
Yes, sir.
Okay, and then there's Officer Salinas going and allegedly making a phone call to Sergeant Flores.
Yes, sir.
And then let's talk about that. You have no idea what that conversation was like, right?
No, sir.
I mean, and I asked you before, you now know that Officer Salinas, who is going to testify probably next, gave different counts of that conversation to Detective Thornton, to the grand jury, and to, I guess, his statement after he made his statement for his Garrity, right?
I'm not sure.
Okay, but what I'm saying is you don't know what Sergeant Flores told him or not.
No, sir.
You have no idea, and you didn't know until this trial that Sergeant Flores was in the middle of an aggravated assault charge himself, incident, and then he took Salinas' call while he's in the middle of that, right?
Yeah, I didn't know.
Are you aware that Sergeant Flores wears hearing aids?
No, sir.
Were you aware that he wears hearing aids that night?
No, sir.
So we're gonna ask, we should ask Officer Salinas about that conversation.
Yes, sir.
But you do know that he didn't record it though, conveniently.
I didn't know that till, I guess.
If I told you that he didn't record it, would that be violating policy?
Record it?
Mhm.
Or?
He's on the call. He hasn't ended his call. He's on the call. He took over from you. It's at the beginning. He should have recorded that conversation with him and Sergeant Flores, right?
Yeah.
All right.
I'm talking with his body cam.
All right, let me interrupt. It's about 5:50. We should probably break for the day. All right? And so let's go ahead and break for the day. Remember the instructions I gave you? They're going to last till the conclusion of the jury trial. Tomorrow we have truncated or shortened our docket. I'm going to ask you to be here no later than 10 o'clock in the morning. Be here 10 o'clock in the morning, and we'll go through the full day tomorrow after 10 o'clock. Have a great evening. See you tomorrow.
All right for the jury?
The previous dinner wanted to hold on to anything that was
Chris
marked.
told me 10.
Yeah, she told me she wanted to hold on.
That's what she told me. Yeah,
We'll withdraw them properly at the
Yeah,
end.
Dico, sorry about that. He
But I
hadn't heard the rest of it.
do you want to
I thought it was a good.
make sure all the exhibits are here?
Yeah, I'll stick around and make sure they're all here.
I know state has 1 through 11, but I kind of,
I've got it
you
all
went a little
laptop.
fast.
Yeah, no, I keep a spreadsheet of it, so I'll have to go through it. You're good on states, right?
Sure.
Well, I don't know they're here, but I know what they have, 1 through 11, that's easy. As you know.
Let me get on this.
Yeah, they can put this.
Let's make sure Mary